Huh? To understand. Release of it.
Adjournments paid by page number 8, serial number 44 to 46.
Serial number 20.1.
We'll adjourn it. We'll adjourn it when she's calling.
25
25. Okay, why? 25 why? Huh? Okay. You're a fresh member at the bar? When did you enroll? Okay. Request of the counsel for the your appellant.
Respondent number 1.
Respondent number 1 released next week.
Adjournments paid by page 8, serial number 44 to 46. Page 9, 47 to 53.
My lord, serial number 52, my lord.
Yes.
My lord, records is necessary. Records will be called for in this case, my lord.
On registry to secure the trial court records. This next week.
Page 10, serial number 54 to 58. Page 11, 59 to 63.
Now,
63.
63. Request of counsel for appellant released next week.
My lord, serial number 64, my lord.
62 released next week at request of learned counsel for respondent number 2.
Serial number 68.
Page number 12, 64 to 70.
Is any objection? At request of appellant released next week. Yes, Vijay Kumar.
My lord, serial number 64, my lord.
ಹೇಳ್ರಿ.
In this case, my lord, the BMTC served unrepresented.
Ah.
That is the only respondent. I'll take notice.
Registry, learned counsel Sri Vijay Kumar D is directed to take notice for R1 registry to show his name in the past list. Copies to be furnished, released next week.
Methods.
Page number 13, serial number 71 to 77.
ಹೇಳಿ. Registry to list MFA 820
6 of
22 released next week. Or registry to secure PCR released next. ಎಲ್ಲಿಂದ ಬರಬೇಕು? ಎಲ್ಲಿಂದ ಬರಬೇಕು ಅದು? List after receiving TCR.
Page 14, serial number 78 to 80. Orders, serial number 1, Sanmati CI.
Appear for appellant, prays for 2 weeks time to pay process, my lord. For R2 and R3, my lord.
2 weeks time granted to do the needful.
Much obliged, my lord.
Number 2, D. Vijay Kumar.
My lord, in this case, my lord, I have to amend the cast title. The respondent is dead. The other relax are already on record. Just I make an endorsement, my lord. A week's time maybe.
Weeks time granted.
So, and in fact, we have done it, my lord. You have already carried out the amendment also.
You
But-
have not filed the amended cost.
Amended, I'll file it.
Weeks time.
Weeks, much obliged, much.
Number 3, NR Rajegoda.
Notice to R2 is dispensed. Liability admitted. As liability is admitted by R1. Both are ready? Deal is next week.
Number 4, P. Suresh.
Application article may be dispensed.
Registry to delete the name of learned counsel Ravish Benny. Huh? So R1 is insurance. Delete the name of learned counsel Ravish Benny as counsel for R2. Seeking dispensation. You're admitting liability? Notice to R2 is dispensed as liability is admitted by R1. Ready? Release on Monday.
5, Chetan B.
What about dispensation? Notice to R1, 2, and 4 is dispensed as liability is admitted by R5. You're for R2. R3 now. At the R2 and consider. 1, 2, and 4 dispense as liability is admitted by whom? R3. R3. Registry to correct the representation of learned counsel B. Pradeep as a counsel for R3 instead of R2 in the cost list. I number 2 of 20 is filed for condoning the delay of 649 days. Having perused the application, affidavit annexed to the application being satisfied with the reasons. IA is allowed delay of 649 days is condoned. However, claimant on being successful shall not be entitled to interest for the delayed period. Release next week.
Number 6, Rishmi Bandar.
One ನಿಮಿಷ.
Registry to list MFS also along with this appeal. Who appears for this insurance? Who has filed that appeal? Huh? Mandalam General Insurance Yaro. B. Pradeep, Learned Counsel B. Pradeep is directed to take notice for R2. Registry to show his name. The cost list.
Number 7, Srinivasan NY.
Admitted. Liability admitted. So nothing on 1 and 3. Notice to 1 and 3 dispensed. Remaining work.
ಮಾತಾಡಿ ಕೇಳಿಸ್ತದೆ.
IA number 1 of 20 is filed. So IA number 1 allowed delay of 34 days condoned. Mr. Ready or next week?
I'm ready.
Check your trial court records.
Number 8, Rishmi Bandar.
My lord, in this case, my lord, respondent number 1, Reliance is served unrepresented. I'll take it.
Team days? No. Learned Counsel Sri Vijay Kumar D. They have to take notice for R1. Free to close name in the cost list. The postal shara of notice to R3 and 4 is returned as refused. Hence the same is held to be sufficient.
R2 to 4.
Yes, R2 to 4. Sufficient.
Much of this.
Relist next week.
Number 9.
Notice to R1 dispensed. Relist next week.
Let I for appellant. Notice to R1 may kindly be dispensed with you.
R1 liability admitted next week. Ready?
Ready next. Other records, without records, I am ready, but the records may be necessary. The injury case.
ಬೇಕಾಗುತ್ತಾ? Registry secured records, trial court records.
Number 11. Mahadev Swami P. Number 11.
Each time granted to do the needful. Yes, sir? ಏನ್ ಹೇಳ್ತಾ ಇದ್ರ ನಮ್ಗೆ ಅರ್ಥ ಆಗ್ತದೆ. Your owner. Your owner.
Artist objection is sir.
Owner of the vehicle.
Counsel submission put together. Office objection. Why R2 made party in this appeal, but respondent to is deleted before trial. Objection written. Or submission alಬೇಕು.
Why? He is deleted.
Was a party before the tribunal. He was tried as number 2 and tried objection.
Why R2 was deleted?
Insurance was more over they have contested. Where the statement of objection contested.
ಯಾರು?
Point number 2. Tara. Page 4, Tara 3 of the award. Statement after service of the service. He has also appeared and read statement of that party.
So he is contested.
Contested.
All right.
Page 5 of the judgment. Therefore,
So you made R2 a party in this appeal also. What's the objection?
ಬೇಕಾಗಿತ್ತ ಇದು ಬೇಡಲ್ಲ ಅದು ಬಿಟ್ಟಿದ್ದೀವಿ ಅಂದ್ರೆ ಅದು ಬೇಕಾಗಿಲ್ಲ ಇದು
Whether R2 was deleted thereafter? Huh? Why you got him deleted?
they have contested. Page 5 of the observation.
Contest ಮಾಡಾದ್ಮೇಲೆ ನೀವು ಡಿಲೀಟ್ ಮಾಡಿದ್ರಿ. On that issue, notice ಆಗ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ. Notice ಹೋಗ್ಬೇಕಾ? Objection, office objection is overruled. For the time being. What is the award now? Don't argue the matter on merits. Deposit the entire amount. Third learned counsel for the appellant. Self history of operation and execution of the judgment and award dated 29/9/21, asked by the 24th additional small process judge, MACT 26 in MVC 1021 of 19. Subject to the condition that the appellant deposits the award amount, entire award amount, within 6 weeks before this court. Deposit the amount. Sorry? Huh? Brain related? ಯಾರಿಗೆ? ಯಾರು? Brain related ailments. No insurance. No insurance. Huh? That's why you have got the insurance deleted. Now you want insurance of party. What is there for insurance to answer before this court? ಏನಿದೆ ಅವ್ರಿಗೆ ಆನ್ಸರ್ ಮಾಡಕ್ಕೆ? Are you sure about your case? Have you read your papers? Have you read your file? Let's call the next man. Next.
13. Rajaram, yes.
Yes, Rajaram. Weeks time granted to comply. Next.
Number 14, Manjunath Devi.
For appellant, my lord. I am for appellant, my lord. Respond number 1 and 2 disband file, my lord. Today file, my lord.
ಏನು?
R1, R2 my dispensation, my lord.
ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ today file ಮಾಡ್ತೀನಿ, my lord. Today.
Weeks time granted to do the needful.
And send the minimum copy to the manager of the company. Business of will be directing to the
R2 is an insurance company.
insurance company. Liability has been remanded back to the tribunal to determination of the compensation.
Notice ಏನಾಗಿದೆ? Whether it is served or not served.
And the extent and here company of
All right.
earlier business of me appear like
Second round. Second round.
Second round.
Learned counsel Sri Krishna Swami is directed to so that to take notice for R2 registry to show his name in the cost list. Copies to be furnished to him. Relist next week. Registry set. ಇದೆಯಲ್ಲ?
My lord, 16, my lord. 16, my lord, may I make submission, my lord?
Yes.
16, my lord, for universal shampoo, I'll take notice, my lord.
Staff?
For Universal Shampoo Insurance Company Limited. 16.
Respondent. First staff. All right. Learned counsel Sri Hegde is there to take notice for R1. Notice to R2 is dispensed as liability is admitted, memo accepted. Relist next week.
After 2 weeks, my lord, may I request, my lord, Bombay it is to go.
All right, after 2 weeks.
Top line, my lord.
17.
Weeks time granted to do the needful. Huh? ನೀವು ಯಾರಿಗೆ? Appellant ಯಾರು? Owner. Claimant has filed execution. What is that notice has to go to whom? Where is your application for stay is not here before the court? ಇದೆಯಾ ಅದು? ನೀವು PF ಕೊಡದಿದ್ರೆ ಹೆಂಗ ಹೋಗುತ್ತೆ? You have not paid the PF. What's your name? What is your name, madam? You are corrected. You are corrected, yeah. You notice. PF paid to the respondents. Meanwhile, by imposing certain conditions, IE number 2 of 23 is taken up. There shall be stay of operation and execution of the judgment and award dated 1/4/23 in MVC 4038 of 21 on the file of 8 additional small causes dated MACT Bangalore CH-5. Subject to the condition that the appellant deposits. What is ordered? How much? You have no insurance. 50% of the award amount within 4 weeks from the date of receipt of copy of the order. Deposit 50%.
Before this court.
Before this court. Non-stating of date of service of notice for purpose of limitation. You are the cross objector. Why you are not stated?
Notice received
Limitation purpose ಗೆ ನೀವ್ ಹೇಳ್ಬೇಕಲ್ರಿ. You have not received notice is what you saying. Which is the appeal file? You have any appeal hakidara ಅವರು? Which is that?
5546 of 2022.
In that you have notice is ordered or not ordered?
23/8/2022 start ಆಗಿದೆ.
But
ನಮ್ಗೆ ಯಾವಾಗ ನೋಟಿಸ್
ಅಂದಿಲ್ಲ.
ವೆರಿಫೈ ಮಾಡಿ ನೋಡಿದಾಗ ಅಪೀಲ್ ಆಗ್ತದೆ.
Keeping open the objections raised. Notice, issue notice to respondent.
I appear for the appellant in case. Really liability is challenged, my lord. For withdrawal of the amount may be disposed of calling for the trial court records, my lord. And certified copy of the judgment in the I have filed it in the connected matter, my lord.
IE 1 of 21 is allowed. The certified copy of the judgment is dispensed in view of the same having been produced in the connected matters. Trial court records ಬೇಕಾಗುತ್ತಾ?
ಹೌದು ಸ್ವಾಮಿ ಬೇಕಾಗುತ್ತೆ. ಇದು ಮ್ಯಾನಿಪುಲೇಷನ್ ಇದೆ, ಇದು ಫ್ರಾಡ್ ಇದೆ.
Your trial court records. Huh? No, this is challenging the liability. Connected material ilva? No, connected material they are not challenging.
ಇಲ್ಲ ಎರಡರಲ್ಲೂ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದೀವಿ ಸುಮ್ಮನೆ ಪೊಲೀಸ್ ರೆಕಾರ್ಡ್ಸ್.
Come, I'll dispose it off together. Liability, she is questioning the liability. Released on 29th.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬರಬೇಕು ಸುಮ್ಮನೆ.
Ordered. Secure trial court.
ಮತ್ತೊಬ್ಬರು
21.
Yes, who was 3 and who's 3 and 4?
And my car. The arrangement was they will take my car by specialist van for Chapa and they will for 7 cars together. Instead of doing that, he drove the car from Kochi to Mumbai and at Chitradurga, this was accident as well. So on the date of the accident, the vehicle was not in my custody. I have filed a consumer case against them in Telangana and the consumer court has given a finding. Each state comes to the finding that the vehicle was in their possession and but therefore only computed on my hardship and loss to the vehicle. These compensations have not been moved. Therefore, I have filed a litigation. Notice was served on them. They have not appeared.
Who's the appellant here? Who are you?
I'm claimant before client.
Claimant. Sir. Your vehicle met with an accident involving the claimant. All right. So you're the owner of the vehicle.
I know.
Was it insured?
Yes, ma'am. But the difficulty below is this, the driver who drove the vehicle has terminated the insurance.
All right. That is for them to pay and recover.
Yes. What happened? This case paid it like not ordered. There are 3 injured persons.
Who appears for insurance company?
I got infected.
So liability is fixed on whom? It's fixed on you. You are not made a party?
I was party. I was responding on the party.
So why are you impleading now 3 and 4?
3 and 4 are people available in practice. Possession of the vehicle on the date of the accident.
What is their role here?
Because the submission is the accident is occurred when the vehicle was in their custody.
So
Therefore, they are parties who will. The insurance company is paid because saying there is a violation of the insurance policy. They are not paying. I'm not done this. I only gave the vehicle to be transported.
correct, sir. Now insurance company is going to indemnify you. Where is the question of this movers and packers being made a party? They are movers and packers.
Yes.
Where is their requirement?
The order is directed me to pay.
Huh?
The order is directed me to pay.
Yes. So you argue that point. Now you are seeking enhancement, huh?
Please. Also, there are
And shift the liability also.
Please.
But you are not challenged.
They are not challenging the liability. They are not filing any.
You are not questioned even the liability. Henry, you are making submission. You are coming and asking somebody else to be impleaded when liability is on you. You are not even questioning the liability. What do you want to do? What is the role of movers here in the claims petition for enhancement?
Okay, sir.
We seek for enhancement with the customer from us.
You have to first argue as to what is the role of these movers and packers in this case. So where does the liability shift from them? You are the owner. You can go and sue them and take whatever you want from them. Have you filed objections to this application? File objections. Relist next week. File madmel barutte. You are not even asking time to file objections. You are not even. How do I know previous who has handled what is happened? File your objections. Next.
22. Rajshekar K.
Delay condone. E1 of 21 allowed delay of 1 days condoned. This next week for admission. Secure trial court records.
23 AM Venkatesh.
My lord, it may be referred to local, my lord. It is settled.
Referred to Lok Adalat.
24.
Request of both parties. ಮಾಡ್ಬೋದಾ? No, delay. You're ready to argue? Are you ready to argue? A1 of 20 allowed delay of 685 days condoned. No
Yes, sir.
interest for delayed period. Secure trial court records.
Now, then we.
I am for appellant, my lord. 16 days delay and condone, my lord.
Panchatulassi.
Hmm, 25.
I am for appellant, my lord. 60 days delay and condone, my lord.
For color. Learned counsel for the respondent seeks a week's time to find color. Same is granted. A1 of 21 allowed delay of 60 days condoned.
ಇದೆ ಎಷ್ಟನೇ ಮ್ಯಾಟ್ರ್?
ಅದು ಲಾಸ್ಟ್ ಬರ್ತದೆ.
ಎಷ್ಟನೇ ಮ್ಯಾಟ್ರ್?
ಅದು ಓದೋ ಪರವಾಗಿಲ್ಲ ಟೇಕ್ ಮಿಸ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ ಇದೆಷ್ಟನೇ ಮ್ಯಾಟ್ರ್?
34 ಇದ್ದಾಗ ಆಯ್ತು ಮುಗಿಸ್ಬಿಟ್ರೆ.
ಟೈಮ್ ಆಗ್ತೀನಿ ನಾನು.
ಎಷ್ಟಾಯ್ತು ಸರ್?
Claimant ಯಾರ್ಗಿಲ್ಲ ಏನ್ ನೆಕ್ಸ್ಟ್ proxy counsel. What's the difficulty? You'll allow the IA. No interest one. Claimant alla. Third learned counsel for both parties. A1 of 22 is allowed delay of 1067 days condoned. However, the appellant on being successful shall not be entitled to interest for the delayed period. Detailed order brief. Delayment. First, we'll just make a note. We'll list next week.
B. Maheshwarappa.
E1 of 22 allowed delay of 60 days condoned. New Year gay. 2. Secure trial court records.
28. Jaykumar T.
Issue notice. Yaarge? Notice to R2 dispensed. Liability is admitted by R1.
additional as to the insurance, inconvenience, more compensation.
List along with MFA zones.
29, PCI.
Huh?
29, P
Climate surveillance.
Issue notice.
30, local judge.
Same issue notice.
31, DJ's problem.
Notice to R1 dispense as liabilities admitted by R2. The notice.
32, debris 60.
Issue notice.
33, 9,
Issue notice.
34, in the
Manjunath, issue notice.
35, Nagaraj RC.
Nagaraj, issue notice.
36, Pavan PG.
Your owner. It is that connected matter. Registry to list MFA 4779-23. This also you are seeking for stay. Pending consideration of IA number 1. IA number 2 is taken up for consideration, imposing certain conditions. There shall be stay of operation and execution of the judgment and award dated 9/3/23. Passed by 4th Additional District Sessions Court at Hassan, sitting at Chandrai Patna in MBC 1008 of 21. Subject to the appellant depositing no insurance. Deposit the entire amount. %50 of the award amount within 4 weeks. Issue notice.
38.
Notice to R1 dispenses liabilities admitted by R2. Issue notice to R2.
39. Swami P.
Mahadev Swami. Issue notice.
40. Grimalaya.
Issue notice.
41. M.V. Vishwakar.
Issue notice.
42.
Liability, no liability.
No?
No liability. Not in the Procedural section 3, 181 of the year. But the 50% before was not available.
Third, counsel for the appellant. Issue notice on IA and main. Pending consideration of IA1, IA number 2 is taken up, proceeding certain conditions. There shall be stay of operation, execution of judgment and award dated 13/9/23 in MBC 1007 of 20. Passed by Senior Civil Judge, Additional MACT Kundapura. Subject to the appellant depositing entire amount. What is challenging liability? 50%. Before this court, 4 weeks.
43. H.C. Shivram.
TCR, Bharat. Secure TCR. Yes,
43. H.C. Shivram.
you have no objection. That is the impeding applicant. Who are you? Who is the appellant? Huh? You're new to the bar. You are new to the bar. You're plaintiff or defendant? Who's this impleading applicant? Is it divergent or concurrent? No representation for respondents. Deal is next week. Appellant is present.
Admission matter. Bill number 44. K.T. Gurudev Prasad.
My lord, I am for the appellant in the connected matter. If other side is ready, my lord, kindly pass over.
You are respondent.
No, I am responding to the first appeal and the second in the connected appeal. I am for the appellant.
Ready?
I am ready.
Yes, argue.
My lord, kindly pass over, my lord.
Ready and pass over.
Alala, if other side is ready, my lord, I will come and
Side is ready.
kindly pass over.
ಅವ್ರು ಕಾಣಿಸ್ತಾ ಇಲ್ವಾ ಅವ್ರಿಗೆ ಅವ್ರದ್ದು
ಇಲ್ಲ ಏನ್ ಕಾಣ ನಮ್ಗೆ ಆಡಿಯನ್ಸ್ ಕೋರ್ಟ್ ಆಡಿಯನ್ಸ್ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ನಂಗೆ ತಾವು ಬಿಟ್ರೆ ಮೋಸ್ಟ್ಲಿ ಕ್ಯಾಮ್ರಾ ಆನ್ ಮಾಡಿಲ್ಲ ಅನ್ಸುತ್ತೆ
ಕ್ಯಾಮ್ರಾ ಆನ್ ಮಾಡ್ಬೇಕು ನಮಗೆ
ಯಾರಿದ್ದಾರೆ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ
ಆಲ್ ದಟ್ ಬಟ್ ವೇರ್ ಇಸ್ ಅ ಕ್ಯಾಮ್ರಾ ಇಲ್ಲ ಅದು ಪರ್ಸನ್ ಇಲ್ವಲ್ಲ
ಇಲ್ಲ ಬರ್ತಾ ಇಲ್ಲ
ಪಾಸ್ ಓವರ್ ಮಿಸ್ಟರ್ ಗುರುದೇವ್
ಪ್ಲೀಸ್ my lord.
45 my lord, I appeal for the respondent case RTC. Matter could be disposed of. Simple injury case. The tribunal awarded compensation of rupees 1,12,480 with interest at 9%.
16, 10, 16. Injury case, huh? Age? Multiplier? 13. Disability?
20.93%.
By tribunal or doctor?
Limb disability. Particular portion of the body.
Sir,
20.93.
or argument ಮಾಡ್ತಾ ಇದ್ದಾರೆ ನೀವು ಯಾಕೆ
Please madam.
After he completes, I'll ask you.
Please madam.
No, what is the income taken by MSC? Any proof?
9,500.
Any proof of income?
And under the tribunal taken little bit of some percent 6,500 income and payment suffering another 55% of the month. And the loss of income being paid up to 1 month 6,500 was taken. The annuities were only 10,000.
What are the injuries?
22.
How many days you were inpatient? No inpatient. Okay, para number 22.
10 days. 10 days. 10 days.
File what is the entry?
22. Inside the exhibit P6 shows different tenderness rate shoulder. External interior dislocation of right shoulder. Compensation of the data from the taken 9,500. That's this data from me.
What about disability?
Disability was at 20.93%, where 32, the income, the criminal was taking 7%. Right, yes, 100%.
Correct, Ado? So you're only on income and other heads. Other heads are, amenities. Later period kotilva.
Later period 6,500, but para 34. Later period 6,500.
Okay.
Amenities less. Incidental expenses.
10 days admission.
Issue.
That's all.
And the liability was fixed. That's part number 135. Here the ratio of 40, 30, 30.
Yes, no, you are appearing for whom, sir?
Malad, KSRTC, Malad.
Corporation.
Nothing more to add, Malad, since he has already stated.
This liability is fastened on you also.
40% is there, 30% and 30% on the other two vehicles. Interest awarded is on the higher side, 9%.
You are not in appeal.
That I am not in appeal, but enhancement, Malad.
That's 6% part.
Yes, Malad.
That's all.
That's all. But my submission is, Malad, compensation awarded is just and reasonable. On record.
Yes.
Please.
The notice I received only for the exponent number 5. I felt in the exponent number 5. Usually, when for student 3 and 5, but I have filed my lord for exponent number 5. However, my lord for exponent number 3 also I find about the same conditions. But the car of my lord also included my lord island conditions. And all are also included.
Then at Counsel Sri Mohan Kumar P takes notice for respondent number 3 as well. The registry to delete the name of Nagarajaya from the cost list. Yes. You can call. Permitted to file wakalat within 2 weeks.
So liability my lord, let's put up these 2 vehicles because 20% each. So I am liable for 60%. Now the case has been plus my lord corresponding to 1. I am liable for 40% of the answer. Because my lord the one of compensation my lord.
Maybe an appeal. So what he is asking is only chart value and a nominal increase in the amenities. Because both of you are not in appeal, so that cannot be now altered here in his appeal. That for future enhanced compensation that can be reduced because again you are not in appeal.
Not to grant just compensation for that can be assessed. Even in our company, my lord, yesterday, conventional rates, the Tribunal has awarded Tribunal has not compensation. Therefore, my lord, in my appeal,
In your appeal, enhancement of consortium is given by which court? Not me. ಯಾವ್ದ್ರಲ್ಲಿ?
last.
No, that must have got adjusted and modified.
Last. Sufficient number.
Which is that appeal?
6945 of 22.
It's an appeal filed by? So in your appeal, the consortium was increased by 20,000. I'll just have a look at it once again, because normally I don't do that. Just then it may not be correct, because they are not in appeal. So you cannot be put in a worse situation. That's what generally I hold. I'll have a look at that again. I may not have signed it. If that is the case, we'll modify that. But good. This appeal is preferred by the claimant seeking enhancement of compensation, challenging the judgment and award of second additional senior civil judge MACT Srirangapatna in MVC 1508 of 16, dated 30th July 2019. Read facts of the case. The claimant was traveling in a KSRTC bus bearing KA09F5076 on 16/10/2016, a Bangalore-Mysore National Highway. When they reached near Funfort SR Patna Taluk, the driver of the bus drove the bus in a rash and negligent manner. Suddenly applied brake when the driver of a car bearing number K04Z3842 and driver of lorry bearing KL58D9436, which was ahead of the bus, resulting in the accident of the bus. Stop. Due to the occurrence of the accident, the claimant, who was an inmate of the bus, suffered injuries on his head, face, and other parts of the body. The claimant was immediately taken to Government Hospital SR Patna, and the first aid treatment was given to him. Thereafter, he was shifted to KR Hospital, Mysore, where he was inpatient for 10 days. He was treated conservatively by undergoing surgery. It is stated that claimant spent around 1,50,000 towards medical expenses and 30,000 towards food and other expenditures. Full stop. Claimant was aged 50 years as on date of occurrence of accident and working as an agriculturist, earning income of rupees 12,000 per month. In view of the injuries suffered in the accident, he filed claim petition seeking compensation from the corporation and the owners of the car and lorry. Respondents 1, 3, and 5, represented through their counsel, filed their statement. Respondent 1 and 5 filed the statement of objections, whereas notice to respondent 2 and 4, those served did not, though were served, did not appear and were placed ex parte. In the statement of objections filed by the respondents, they denied the involvement of the vehicle, the negligence attributed to them, and that the accident was caused due to the negligence of the other vehicles. However, not admitting their liability, sought for dismissal of the claim petition, did not, however, admit the age, avocation, and income so claimed by the claimant in the claim petition. Full stop. Based on the pleadings, tribunal framed relevant issues for consideration. On the basis of evidence, both oral and documentary, tribunal the basis of the issues, the claimant examined himself as PW1, got marked exhibit P1 to P14, examined the doctor as PW3, and got marked exhibit 15 and 16 through the doctor. Whereas the respondent number 1 examined the driver as RW1, but however did not produce any documents. Other respondents did not read evidence. Based on the evidence, both oral and documentary, tribunal awarded total compensation of 1,12,480. Fasten the liability against the respondents in the ratio of 40, 30, and 30 to the KSRTC bus, the insurer of the lorry, and the car and the insurer of the lorry. Tribunal also awarded interest at 9% and directed the compensation to be paid within 30 days. This is a vehement contention of learned counsel for the appellant claimant. The tribunal is committed in error in not awarding just and reasonable compensation, has assessed the income of the claimant on the lower side, taken the disability also on the lower side. Full stop. He contends that under other heads, tribunal has not awarded just and reasonable compensation. Therefore, seeks enhancement of the compensation. Per contra, learned counsel appearing for the corporation and the learned counsel representing the insurance company of the two vehicles involved in the accident vehemently contend that there is no illegality or arbitrariness in the award passed by the tribunal, as tribunal has taken correct income in view of there being no proof of income and assessed the disability based on the evidence adduced by the doctor PW2. So also under other heads, reasonable compensation has been awarded. In all, the compensation is just and reasonable. It does not call for interference. The counsel for the corporation contends that there is no liability absolutely on the corporation, as the driver of the bus had to apply his brake because of the two other vehicles which were ahead of the bus, which had suddenly applied brakes. Therefore, the liability needs to be shifted to the insurer of the car and the lorry. Similar arguments have been put forth by the learned counsel representing respondent number 3 and 5, who contends that the KSRTC bus should have maintained distance and should have applied the brakes well in advance to avoid any kind of accident. Therefore, he seeks to shift the liability on the corporation. Accordingly, they seek to dismiss the appeal. Full stop. I have heard learned counsel for the claimant, corporation, and the insurance company. It's not in dispute that accident occurred on 16/10/2016, and the claimant was an inmate in the KSRTC bus, which met with an accident involving two other vehicles, that is the car and the lorry, leading to the injuries sustained by the claimant. To establish these aspects, the claimant has produced exhibits P1 to P7. The police records depict charge sheet yaar mein lakidare more vehicles mein. The charge sheet depicts that the FIR and the charge sheet depict the filing of the case against the driver of the bus and the driver of car as well as the driver of the lorry. Therefore, when such being the case, negligence is rightly attributed against the drivers of three vehicles, consequently their insurers and the corporation. Exhibit P8 to P16 are the medical records to show the treatment and financial expenditures met, along with the disability certificate produced at exhibit P15. Coming to the age, avocation and income of the claimant as on date of occurrence of accident, it is stated that the claimant was aged 50 years. The appropriate multiplier would be 13, which is rightly taken by the tribunal, and the same does not call for any interference. The doctor has adduced evidence opining disability to an extent of a particular limb of the body to 20.93%. However, he has not given the disability to the whole body. The tribunal has assessed the disability to the whole body at 7%, which also does not call for interference. The only point that calls for interference in the awarding of compensation is the income assessed by the tribunal. In view of there being no proof, tribunal has assessed the income to be 6,500 per month. The notional income chart of the Legal Services Authority for the accident year 2016 is 9,500. Same request to be taken in the present case on hand. Therefore, the loss of future earning capacity due to disability would be 1,03,740. 1,03,740 as against 70,000, 70,980 awarded by the tribunal. Full stop. Towards pain, shock, and agony, tribunal is awarded 25,000. This court deems it appropriate to award additional 25,000 under this head. Towards loss of income during treatment period, 6,500 is awarded. In view of this court enhancing the income from 6,500 to 9,500, considering the injury suffered, there's a fracture. 3 months period would be required to recuperate and get back to work. 9,500 into 3. 28,500 is awarded under this head. Towards discomfort, loss of amenities, tribunal is awarded 10,000. I deem it appropriate to award an additional amount of 25,000 under this head. Towards food, nourishment, attendant charges, no compensation is awarded. Claimant was inpatient for 10 days. 15,000 is.
Records are not there to show that inpatient and ಅದಕ್ಕೋಸ್ಕರನೇ ಅವ್ರು ಅವಾರ್ಡ್ ಮಾಡಿದ್ರು.
You are inpatient for 10 days. Who said you said?
10 days ಅಂತ ಬಂದಿದೆ, but federal has not accepted it.
No. What reason? Is it explained why? Where is that? Huh?
24, para 24.
What is the reason?
They're not issuing easy cards.
You are not, you are admitted or not admitted?
Admitted sentence.
No document has been produced. Para 24.
Have you produced any document?
No, not that.
Okay.
But doctor said that when prior 26 thereafter is shifted to 311, 16, 27 was shifted to Natal last. But exactly what stated how many days for the presentation.
Fracture ಆಗಿದೆಯಲ್ರಿ?
Actually, surgery and
It cannot be that he will not be admitted when he has got fracture.
But he has not produced para number 24.
And go on those technicalities. 26, he says there is a fracture of AC joint. He was shifted from one hospital to the other, and then the shoulder bones were also fractured. How can he be treated without being admitted?
Dislocation of right shoulder. As per X-ray.
Correct. Fracture of AC joint, right shoulder.
That is as per the doctor. As per X-ray, my lord, it is dislocation.
So dislocation does not require any surgery, surgical intervention.
Certainly it needs, my lord, but it is not a fracture. Fracture is this.
All right. Food nourishment and treatment. 10,000 is awarded notionally. In view of the above, claimant would be entitled to total compensation of as against 1,12,480. Accordingly, pass the following order. Appeal is allowed in part. Judgment is modified. Claimant is entitled to total compensation of so and so. The interest awarded by the tribunal is to retain for the enhanced compensation. The interest shall be paid at 6% per annum, which shall be the same shall be paid within 4 weeks from the date of receipt of copy of the order. The entire compensation amount shall be released in favor of the claimant upon proper verification. I will look into that judgment which you mentioned. Or yes, tell him to place it on my table. Whether there was case and counter appeal or only insurance appeal. I'll have a look.
46, Patel D. Curriculum.
Respondent to is therefore, requesting my lords to direct the panel advocates to take the notice for respondent number 2.
Yes. Yes, who appears for Royal Sundaram General Insurance?
Yes.
Huh?
Yes.
Ravi S. Samprati, H.S. Lingaraj.
Ravi Samprati, no? Is he available today? Registry, Learned Counsel Ravi S. Samprati is directed to take notice for R2, who is in the panel of Royal Sundaram General Insurance Company. Registry to show his name in the cost list. Who's R1? He's the owner or what?
He's the the claimants are the wife and the children.
All right. So the liability is fastened on the owner or the insurance company?
So liability, as far as liability is concerned, it's not questioned by law, so it's complete and it's not questioned.
All right. You are now asking for a enhancement for only on quantum. All. We'll have it next week, Mr. You're Suhas or Shreyas? Shreyas, I remember your name. Yes, so we'll have it next week. Yes, we have listed show the name of Ravi Samprati. So he will come and you can argue. Relist this matter.
Copy of it.
Relist this matter next week. You can carry one extra copy in case he doesn't have a copy, you can give it to him.
47. Satish HK.
47 ballot I appear for the respondent KSRTC.
Yes, sir.
Post stop. Issue number. Injury case.
Mr. Nagaraj,
Yes, Malad.
what about R2, 3 and 4?
I will take notice, Malad. Yeah, all are one and the same parties.
Correct. Registry to show the name of Learned Counsel Sri Nagaraja K for R2, 3 and 4 in the cost list.
Please, Malad.
Yes, Satish,
Case of injury, MS of the father.
ready?
Ready?
You're ready, sir?
Yes, Malad. Para 16, Malad.
Marginal idea,
It
para
is
16.
Compression fracture involved in creating any plate of legal particular fracture.
Injury case, huh?
Injury
Age,
And
age.
injury.
case, 52 years. Doing salary business and earning up to 30,000. It's no document. Tribunal taken 8,000, first time income is 2017, 11,000.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
8,000.
8,000. ಎಷ್ಟು ಆಗ್ಬೇಕಾಗಿತ್ತು?
11,000. 2 days inpatient. Taken treatment as an operation for 6 months. After has been examined,
Yes, ಏನೇನು?
disability support, yes, about 20% disability.
Tribunal?
Fine, my lord. Tribunal taken only 6.36%.
20% to the whole body ಹೇಳಿದಾರಾ?
Spine. The backbone, my lord.
Spine.
Particular body, spinal organ. For that reason, at least 50% has to be considered. 20%, 10% of
In fracture of the spine.
fracture of vertebral. Deeper fracture.
Fracture ಆಗಿತ್ತು.
That's spinal. Loss of ability only 5,000 has been offered.
How many days inpatient? 2 days.
2 days inpatient. All ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲ only 5,000.
ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ನೀವು ಆಕ್ಚುಯಲ್ ಕೊಟ್ಟಿಲ್ಲ. ನೀವೇನು ಕೊಡದಿರ ಕೋಟ್ ಏನ್ ಮಾಡ್ಬೇಕು?
CT scan reports ಕೊಡ್ತಾರೆ.
What about this loss of income during treatment and rest period? You are working as?
Doing salary business, I think 30,000. Rest again 6 months.
What has the doctor said? Whether you need any further treatment, any rest? ಏನಿಲ್ಲ. But then you want attendant charges 500. Loss of future. That's all.
Food and nourishment.
ಏನ್ ಫುಡ್ ಅಂಡ್ ನರಿಶ್ಮೆಂಟ್ ನೀವು ಇನ್ಪೇಷಂಟ್ 2 ದಿನ ಅದ್ರಲ್ಲಿ ಏನ್ ಕೊಡೋದು?
Taken treatment as an operation for
Yes.
Para number 17 shows 52 years. Para number 19, income taken 8,000 rupees. Sari business ಅಂತ ಹೇಳ್ತಾರೆ, ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಆಮೇಲೆ she was admitted to the hospital only for 2 days. For which malad ಅದು compression fracture of T-tool vertebra ಅಂತ ಹೇಳ್ತಾರೆ. ಹಿಂದಕ್ಕೆ ಹಂಪ್ಸ್ ಬಂದಾಗ ಬ್ಯಾಕ್ ಸೀಟ್ ಅಲ್ಲಿ ಕುತ್ಕೊಂಡಿದ್ರೆ ಸ್ವಲ್ಪ ಈಗ ಆ ತರ ಆಗಿರುತ್ತೆ ಅಷ್ಟೇ. ಅದು ಫ್ರಾಕ್ಚರ್ ಅಲ್ಲ. ಫ್ರಾಕ್ಚರ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ರೆ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಅಡ್ಮಿಟ್ ಆದಾಗ ಆಪರೇಷನ್ ಮಾಡ್ಬಿಟ್ಟು ಅದನ್ನ ಇದ್ ಮಾಡ್ತಾರೆ. ಇದೇನು ಬರೀ ರೆಸ್ಟ್ ಅಂತ ಹೇಳಿರೋದು ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ 5,000 rupees ಫಾರ್ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಇನ್ ದ ಅಬ್ಸೆನ್ಸ್ ಆಫ್ ಎನಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮೇಲೆ 5,000 rupees ಕೊಟ್ಟಿದ್ದಾರೆ. She has not produced any medical bills. and loss of amenities 5,000 rupees ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಸ್ ಫಾರ್ ಎಸ್ ಇನ್ಕಮ್ ಮೇಲೆ ಅದನ್ನ ನಾವು ಇದ್ರ ಪ್ರಕಾರವಾಗಿ ಇದು ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಅಷ್ಟೇ. ಬೇರೆ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ. ಆಮೇಲೆ ಡಿಸಬಿಲಿಟಿ ತಗೊಂಡಿರೋದನ್ನು ಕರೆಕ್ಟ್ ಆಗಿದೆ 6%. ಇಟ್ ಈಸ್ ನಥಿಂಗ್ ಆಕ್ಚುಲಿ. Multiplier of 11 is applied.
All correct.
Interest 7% ಇದೆ, ಅದನ್ನ ಫ್ಯೂಚರ್ ಇದಕ್ಕೆ ಎನ್ಹಾನ್ಸ್ಡ್ ಅಮೌಂಟ್ ಗೆ 6% ಮಾಡಿ.
But by the claimant questioning the award judgment and award of the second additional senior civil judge MACT Chitradurga in MVC 985 of 18 dated 23rd June 20. This appeal is founded on the premise of meager inadequate compensation. Three facts. The claimant, along with her husband, were traveling in a KSRTC bus bearing registration number KA 19F 2857 from Ballari to Chitradurga on National Highway number 150-A. When the bus came near Rampura Gaura Samudra gate of Molkalamuru Taluk, driver of the bus drove the same in a rash and negligent manner so as to endanger human life and safety. And due to the impact of the bus on the road humps in a high speed, the claimant sustained injuries and was taken to General Hospital, Chitradurga. This stated that the claimant was hale and healthy prior to the occurrence of the accident and the injuries sustained by him. He was involved in quarry business, in sari business. Quarry, sari business, and was earning rupees 30,000 per month. In view of the injuries sustained and medical treatment expended, he filed a claim petition seeking compensation against the respondent. The respondent, on appearance, filed a statement of objections denying the claim made by the claimant, disputing the injuries suffered and the magnitude of the injuries as stated by the claimant. It also pleaded that no serious injuries have been suffered. It is merely because of the bus having gone on the speed breaker. Therefore, there is no serious injuries suffered and sought for dismissal of the claim petition. On the basis of findings, Tribunal framed relevant issues for consideration. To establish the same, claimant got examined herself as PW1, marked exhibit P1 to P23, and examined the doctor as PW2. Whereas the authorized agent of respondent number 4 was examined as RW1, got marked exhibit R1. On the basis of the evidence adduced by both the parties and hearing the submissions of the counsel for both sides, Tribunal awarded total compensation of 86,800 86,860. Being agreed, the claimant has before this court seeking enhancement of compensation. It is not in dispute accident occurred on 23/12/17 when the claimant was traveling in the KSRTC bus, which met with the accident causing injuries.
Para 20.
No, whether there was any accident involving any other vehicle at all.
ಇಲ್ಲ ನಮ್ದು ಆ ಹಂಪ್ಸ್ ನ ಇದು ಹೋದಾಗ ಸ್ಪೀಡ್ ಆಗಿ ಹೋದಾಗ ಹಿಂದೆ ಕೂತ್ಕೊಂಡ್ರವ್ರಿಗೆ ಈ ತರ ಹಿಂಗಾಗಿದೆ ಅಷ್ಟೇ.
ಎಲ್ಲ ತೆಗ್ದಾಕ.
ಇಲ್ಲ ಆ ತರ ಆಕ್ಸಿಡೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಇದು ಈ ತರ ಬರೀ ಸಿಂಪಲ್.
Due to the rash and negligent driving of the driver of the bus, having gone on the speed break, the road humps in the high speed, the claimant suffered injuries to the backbone. The vertebra, T12 vertebra, and it is stated to be grievous in nature. Hence, the claimant relies on the exhibits P1 to P9 of the police records, wherein FIR and a final report came to be filed against the driver of the bus for rash and negligent driving, leading to the injuries suffered by the claimant. The police records are not disputed. So also the medical records placed by the claimant for having undertaken the treatment for the injuries suffered due to the negligence of the driver of the bus. Full stop. It is stated that the claimant was aged 52 years. The tribunal has taken the multiplier of 11, which does not call for interference. The tribunal has assessed the income to be 8,000 per month. Whereas the notional income chart for the accident year of 2017 is 11,000. Therefore, the income requires to be enhanced to 11,000 per month. The doctor is given a disability, permanent disability, to an extent of 20% to a particular organ, which is been considered by the tribunal, and the disability is assessed at 6% to the whole body. I do not find any reason to interfere with the same. Same is retained. Therefore, the loss of future earning capacity due to the disability would be 11,000 into 12 into 11 into 6%, 87,120 as against 63,360 awarded by the tribunal. Towards pain and sufferings, 5,000 is awarded. We deem it appropriate to award 25,000 under this head. Towards medical expenses, actual amount is awarded on the basis of bills produced by the claimant. Is not disturbed. Towards loss of amenities, 25,000 is awarded as against 5,000. Towards loss of income during period of treatment, in view of the claimant having suffered certain injuries to the vertebra, as proclaimed by the doctor, PW2, at least 3 months would be required to get back to normal day-to-day activities. Hence, 11,000 into 3, 33,000 is awarded under this head as against 8,000. Towards attendant charges, 500 is awarded as the claimant was impatient for 2 days, I do not find any need to interfere with this under this head. Same is retained. View of the above, claimant would be entitled to total compensation of
1,70,000 plus medical.
7,120 minus 25,000 plus 25,000 plus 5,000. These are 33,000. 1,75,620.
Yes. 1,77,740 ಬಂತು ನನಗೆ.
87%.
87,120, pain and suffering is 25,000, amenities 25, laid up period 33, medical expenses 7,120.
No, 5,000. 5,000 plus 500.
Plus 500.
As against 86,860. Accordingly, I pass the following order. Appeal is allowed in part, judgment is qualified, claimant is entitled to so and so as against so and so. The other terms, conditions is retained. The enhanced compensation shall be paid by the corporation with interest at 6% within a period of 4 weeks from the date of receipt of copy of the order.
Please.
Number 48.
Which is the serial number?
48.
Yes. You're ready. ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು ರೆಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Quantum and?
Quantum and not very element, only 2 points. Very clear.
ಏನ್ ತಗೊಂಡಿದ್ದಾರೆ ಕ್ವಾಂಟಮ್ಗೆ? What is the quantum? What are you disputing quantum? Income proof ಇದೆಯಾ?
The claim petition it says that you are the engineer.
What is taken by the tribunal?
You are taken 16,000.
1,5.
Yes, he is student. BCom. Here given. All content has been given by you.
Then you let him argue.
That everything.
Then let him argue next week. ಜೋರಾಗಿ ಹೇಳ್ರಿ. ನಮ್ಗೆ ಹುಷಾರಿಲ್ಲ, ನಾವು ಜೋರಾಗಿ ಮಾತಾಡ್ತಾ ಇದೀವಿ. ನೀವು next week.
49. Gopal Krishnayan.
ಯಾರಮ್ಮ? Not filed vocal. Dabali, FS Dabali. Alright. ಇದರಲ್ಲ. ST Naik is here. All right. There's a counsel for appellant present, no representation for respondent released next week.
P. Counsel MY.
Yes, sir. Yes, sir.
Ready?
14/9/2017. 14/9/2017. Age 65 years.
Age?
65 years. Depending on their wife and children. Tribunal taken 9,000. 11,000. Consortium number 40,000 each.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ
40,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Another
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ
Since Amputation from 14/9/2017 to the date 24/9/2017. 10 days.
Huh?
Nearly 10 days.
10 days.
10 days.
You have produced a bills. Have you produced
I
bill?
produced bills, but inpatient details was
ಅದನ್ನ ಏನ್ ಮಾಡ್ಬೇಕು
the list. 10 days. Incurred so much amount. My medical bill was produced by 2,57,000. Tribunal was given.
ಡಿಸ್ಚಾರ್ಜ್ ಸಮರಿ ಏನಿಲ್ವೇನು ಅದು ಐ ಮೀನ್ what do you call that medical
He was inpatient in the judgment also, shows he was.
you agree
They have not produced the bill.
then how to consider that medical expenses ಅಲ್ಲಿ ಬಿಲ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆಯಾ
Yes. 14 only. He was admitted 14/9/2007. 20. He died at hospital 24/9/2007. Here he 10 days.
para number
Para number 14. Bill 88. Relevant admission date number 14/9/2017. And next page number the date of hospital 24/9/17.
Hmm. 10 days.
Yes. Only.
Hmm. So only thing is the income will have to be enhanced to 11,000. Multiplier ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ
Multiplier by 7.
7
Future plus was taken.
7 into
Not correct.
They about 60.
The Tribunal was considered 10%.
and 10% future prospects ಕೊಟ್ಟಿದ್ದಾರೆ how that also is more
900 rupees 60.
multiplier 6 ತಗೊಂಡಿದ್ದಾರಾ 7 ತಗೊಂಡಿದ್ದಾರಾ
9,000 plus. Multiple 7%.
that also is wrong no that's correct 65
60. 10% decalculation.
you know 9%
Future cost of 10% and related. For the 6 years ago, they
ನೀವೇನು ಅಪೀಲ್ ಮಾಡಿಲ್ವಲ್ಲ
income aspect.
Referred. This is an appeal preferred by the claimants challenging the judgment and award of the senior civil judge JMFC at Pandavpura dated 16th April 2019 in MVC number 1557 of 2017. This appeal is founded on the premise of inadequate compensation awarded in the case of unfortunate death of Kalegowda. Kalegowda. The claimants are none other than the wife and son who are dependents on the said Shri Kalegowda. Brief facts of the case. Shri Kalegowda was traveling in the KSRTC bus is traveling along. This was coming from KSRTC bus stand towards TB Circle. While he was waiting for an auto rickshaw in front of the police station at 12:30 p.m. on 14/9/2017. At that time, one motorbike bearing registration number KA54J7491, ridden by its rider in a rash and negligent manner, came in a high speed and dashed against Kale Gowda, who was standing by the side of the road waiting for the auto rickshaw. And consequently, he fell down, suffered multiple serious injuries on his head and to his legs and other parts of the body. Full stop. Kale Gowda became unconscious and he was immediately taken to Government Hospital KR Pette, wherein first aid treatment was meted to him, and thereafter he was taken to KR Hospital Mysore, where he was admitted in the emergency ward as inpatient for 2 days. Subsequently, Kale Gowda was taken to Anaga Hospital, Mysore, where he was admitted as an inpatient. However, due to these financial difficulties, he was again shifted to KR Hospital, Mysore, where he was inpatient for 10 days. Due to the injuries suffered in the road traffic accident, Kale Gowda succumbed to the injuries on 24/9/2017 after a period of 10 days. It is stated that the claimant spent substantial amount for treatment and they have lost their loved one and they incurred financial expenditures towards medical bills and other funeral expenses. It is stated that Kale Gowda was aged 64 years as on date of occurrence of accident. He was doing agriculture work, earning rupees 20,000 per month. Due to the sudden untimely death was due to the negligence of the rider of the motorbike. The family, the claimants, have lost financial support, love and affection of their husband and father respectively. On service of notice to the respondents, they appeared and filed a statement of objections. They denied the claim made by the claimant in the claim petition. So also the negligence attributed to the rider of the motorcycle and the respondent number 3, insurance company, had insured the bike, so the respondent number 2 implicated the respondent number 3 to indemnify his claim in view of the policy being enforced. The insurance company filed its detailed statement of objection, denied the claim, including the age avocation and the driving license, age avocation of the claimant, the deceased, the driving license of the validity of the driving license of the rider of the motorcycle, which however is subject to the terms and conditions of the policy. Accordingly sought for dismissal of the claim petition. Based on the proceedings, Tribunal framed relevant issues for consideration. In order to substantiate the issues and prove the case, claimant number 1 examined herself as PW1 Another witness as PW2 and got marked exhibit P1 to P18. No evidence was adduced on behalf of the respondents. After hearing the learned counsel for both the parties and on going through the entire evidence, both oral and documentary, Tribunal awarded total compensation of 8,81,000 with interest at 9% per annum. Held the liability as against respondents 1 to 3. And directed respondent number 3 to pay the compensation. Full stop. Being aggrieved by the meager compensation awarded, claimants are before this court seeking enhancement. It's the vehement contention of learned counsel for the appellant claimants that the tribunal is awarded meager compensation without taking into consideration the proper income of deceased for amputation. So also on other heads, tribunal is awarded meager compensation which calls for enhancement. Hence, he seeks to allow the appeal. Per contra, learned counsel representing the insurance company, as a respondent number 3, contends that the judgment and award passed by the tribunal is in fact excessive and seeks further contends that just and reasonable compensation has been awarded. And he seeks to dismiss the appeal preferred by the claimants. It is not in dispute. An accident occurred on 14/9/2017 when Shri Kaligowda was standing near the TV circle waiting for the auto rickshaw when the rider of the motorcycle rode the same in high speed and dashed against him, leading to the injuries suffered by the deceased, who later on succumbed to the injuries. In order to establish these facts, claimants have produced exhibits P1 to P18. The
In order to establish these facts, claimants have produced exhibits P1 to P18.
Exhibit P1 to P8 being the police records, establish the act of filing of FIR and charge sheet against the rider of the motorcycle, which clearly depict that the negligence is rightly attributed by the tribunal as against the respondent, against the rider of the motorcycle, and consequently against the insurance company, owner of the vehicle, which is insured with the respondent number 3 insurance company. The other exhibits P9 to P18, show the financial expenditures meted out by the claimant. Full stop. In order to assess the income, the claimant has not produced any material before the court of the deceased. However, stated that he was working as an agriculturist. What was he working as? Agriculturist. The tribunal, in view of non-production of any proof of income, has assessed the income to be 9,000 per month. However, the notional income for the excellent year 2017 as per the chart, Legal Services Authority chart, is 11,000 per month. Same is required to be taken in the present case on hand. The age of the deceased is shown to be 65 years. The multiplier adopted by the tribunal is 7, which is correct and does not call for interference. What about deductions in this case? What about deduction? Which paragraph it is mentioned?
Page 14. Page 14. In page 14.
14 of the internal page.
Internal page. Last 10 minutes. 1/3%.
The tribunal has added an additional income of 10% towards future prospects and deducted 1/3 towards personal and living expenses. The addition of 10% may not be disturbed in view of there being no counter appeal or cross appeal preferred by the insurance company. The deduction of 1/3 is correct, which does not call for interference. Therefore, in view of the above, the loss of dependency, in view of enhancement of this court of the income would be 11,000 as 10%, 1,100. Correct, but you are not in appeal. All right. What is the difference if that is not deducted? Just calculate and tell me.
77.
If the 10% which is added as future prospects, if that is removed and this 11,000 is taken, would the total compensation come down or it will go up?
61,000 difference. 61,000 difference. 10% added comes to 6,77,628. If 10% deducted, 6,15,972. 61,000 difference.
This is after adding 10%.
After adding 10%.
This is not adding.
Not adding.
600 excess.
So we'll modify the judgment by removing that 10%. Because we are this court is enhancing the income. Just compensation. We are Just read the paragraph.
The tribunal has added the 10% income towards and deducted 1/3 towards personal and expenses. The addition of 10% may not be disturbed ಅಂತ ಹೇಳಿದ್ರಿ.
Addition of 10% towards future prospects may not be correct, as the same is not contemplated in the case of pranayaseti. Therefore, that would have to be disturbed. That would have to be interfered by this code in view of this code enhancing the income of the deceased from 9,000 to 11,000. Thereby, despite there being no appeal preferred by the insurance company, this court, in order to avoid just and reasonable compensation, is required to modify the order to see that justice and equity is meted to both the parties. The loss of dependency, therefore, would be 11,000. No, 7,334 ಆಗುತ್ತೆ income. Correct? 7,333.
Because,
Income would be taken at 7,333 after deducting 1/3 towards personal and living expenses. Into 12 into 7. 6,16,056.
15,972.
Huh? 6 lakhs?
15,972.
15,972. As against 5,54,400 awarded by the tribunal. Towards medical expenses, tribunal is awarded 2,57,000 on the basis of actual bills produced. Same does not call for interference. Under the head of loss of consortium, tribunal is awarded 40,000. Whereas there are two dependents, each would be entitled to 40,000. Hence 80,000 is awarded under this head. Plus an additional amount of 10% escalation for one block period, hence 8,000 is added. Towards funeral expenses and loss of love and affection, which should have been another amenities. That is for towards which head? Towards estate. 30,000 is awarded, which also would incur an additional 10% escalation. Hence 33,000 is awarded under this head. In all, claimants would be entitled to total compensation of though no documents are produced by the claimants to show that the deceased was inpatient for 10 days, no material is placed. However, on the basis of evidence adduced by the claimants and the doctor, it appears the date of accident is on 14/9/2017, and the deceased succumbed to the injuries on 24/9/2017. Hence 10 days, the deceased was in the hospital taking treatment. This amount has not been awarded under this head. No amount is awarded under this head. This court deems it appropriate to award an amount of rupees 20,000 under this head. In view of the above, claimants would be entitled to total compensation of 10,13,970 as against 8,81,400. Accordingly, pass the following on. Appeal is allowed in part. Judgment and award is modified. Judgment and award dated so in MVC number all. The claimants would be entitled to total compensation of cash as against 8,81,400 with interest at 9% per annum as stipulated by the tribunal. The enhanced compensation shall be paid at the 6% interest by the insurance company within a period of 4 weeks from the date of receipt of copy of the order. You have deposited the entire amount? MSCT, you have withdrawn?
Yes.
Withdrawn. What is the enhanced amount? 2 lakhs.
2 lakhs.
The entire enhanced amount shall be dispersed in favor of the claimants to a proportionate share stipulated in the award of the tribunal upon proper verification.
Sixty-one, Gopal Krishnan.
Yes, you are ready. One.
18. Age of 29 years.
Just pull the mic down. I can't hear you.
Age of 29 years. 80% of the disordered
Left leg above knee.
play.
What was the avocation? Labor.
Somebody at Canada practices with 80% color and functional disability 100%. You don't consider that 20% loss of learning capacity and future prospect also is not added. And 2018 action to that woman taking that income.
How many days he was inpatient?
38 days.
How much is the income that should be taken? How much should be taken, sir? All right. There is a discussion with regard to disability by the doctor on the tribunal. 41 or 3.
41.
Please read 41.
It is relevant to what is the cost that is there. PWC are other than like 15. Say that right out here, take it out the gesture that is. So not discussion about the application of the complaint of the petitioner. And left leg of the petitioner is complicated. I have to construct that 80% of the whole body is not on the other side. Therefore, it is considered that 20% of the whole body. And the same is sufficient for the application of the petitioner was working as industrial. All of us are on the petition and earning a in order to implementation that the petitioner comes under the category was particular for the period of 4 months. Income is provided under the head of the cost of income to the head of recently to meet the ends of the justice concept of the I think it just and the reasonable this the head of the cost. Coming to the question of the compensation, so they assess the constitution of the age of the at the time of the incident in order that is the
Age is 25, is it?
29.
29 antina.
5 months.
Huh?
25 years.
Then why are you saying 29 years? You're arguing for your client or against him? 29 andre, you will get 17. 28, 25 andre, you will get 18. So you have to decide what you want. But why are you saying 29? Forget about that, sir. When tribunal has given you 25 years, you have to know what to argue. The multiplier is 18 is correct. Yes. Why the disability is taken at 20% when the doctor has expressed it at 80%? Record video. Record video. Today, exhibit P11. What is the law on the point when there is a doctor's opinion with regard to disability of 80%? What is the law? What does the court say? Anything above 80%? No, that is only, is it now to the whole body taken by the doctor? Or it is assessed to one particular leg? Yes. 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 Read it. I am not. Para 8 and.
Loss of functional disability is there.
Sir, I don't know. You have to read and convince me what is para 8. Please read para 8.
This is the compensation payment that last parameter. Applying the multiplier method, feature prospect and advancement of the life and their function taken into consideration then. We are the of the view that there is merit condition of the and the opposite discount with regard to future prospect also be applied in the case of the appealing the summary descriptive of 51.1 the of the say on the basis of the judgment and national insurance company on cases the more specific paragraph 59.2b the age of the applicant should be 15% of the actual salary in the present case. The in the letter the interest of the rate. Here as your question is 9% is standard. 31.1 melody is the full body is 70 50% melody as per credit.
Whether he was married? Hmm? Whether he was married or ಹೇಳಿಲ್ಲ. What is your argument on that?
Okay, saying that loss of ability is of the loss of the prospect and loss of ability is
Yes, what do you say? No, no, leave it to Lordship. Are you sustaining the order or you agree to his contention? Though I will say that you are not agreeing in the judgment.
Doctor who has proposed is not a treated doctor and he has not assessed the functional disability.
Whether he's treated or not treated, it doesn't matter to the claimant who has lost his leg. That's a fact. That can be disputed whether by an orthopedic surgeon or whether by a physician. It's a fact that he has lost his leg, left leg, above knee. So only question is what is going to be the functional disability? Whether it has to be 80% as stated by the doctor, or 50% or 30%. So this judgment which is relied even 31%, the court says, which is a full bench judgment. Future prospects is required to be added. Plus, he is not arguing whether he is married or not, that he doesn't know. Marriage prospects has to be given. Just got it there, loss of.
I was one of the
What you are going to do? Who's going to marry this young man, 25 years? Even if he wears prosthetics. Yes, that's all. Yes, Madam Geeta, what is generally the courts awarding in such cases of amputation of above the knee, percentage of disability? He has lost his leg right above the knee, one leg. Will have to be added. So after adding future prospects, another component of marriage prospects also should be awarded, or? Then, so along with that, prosthetics also comes into play.
Saying that he is going for a processes and maintaining the artificial limb also incur some charges every 3 years or 4 years. If there is an evidence to that effect, there are cases where it is given that.
So this is generally awarded. So this judgment of the Supreme Court is followed.
Yes.
Sir Gopal Krishna, in death cases, we have to be careful as lawyers, sir. It is going to be on your argument, the court is going to award compensation. Nimmu one small argument in the our guest lava barutte nimge, you have to think about it. These are people who are laborers. That amount will probably he may start some business and sustain his family. So this is, you have to be careful, not more, regularly argue like any other case. Injury case, he is alive, something here and there is okay. These cases you have to, where now he's lost his life, nobody's going to marry him. You have to be sure and you have to convince the court and argue this appeal preferred by the claimant. Of course, I appreciate you are relying on the judgment which is in your favor. I appreciate that fact, but I am advising you, don't take it in the negative. Just an advice to the members of the bar. Appeal is preferred by the claimant against the judgment and award of the Motor Vehicles Accidents Claims Tribunal, Bangalore, CH-2 in MVC 2174 of 18, dated 30th November 2019. This appeal is founded on the premise of inadequate and meager compensation awarded to the claimant. Brief facts of the case. This is an unfortunate case of amputation of the claimant's left leg above the knee during the course of accident while he was proceeding on his Honda Unicorn motorcycle bearing registration number AP 03AY 4278 on 1/1/2018. While the claimant was riding his motorcycle towards Srikalahasti side from Renigunta on the main road NH71. While he reached the Ayyappa Swami temple near Iskathagalli village, Yerpedu Mandal, Tirupati urban district. At that time, a lorry bearing registration number KA01AD8247, driven by its driver in a rash and negligent manner, so as to endanger human life and safety, dashed against the motorcycle ridden by the claimant and knocked him down, ran over the his left leg, causing serious crush injuries to his left leg. Claimant was immediately taken to the nearby hospital at Srikalahasti, and after administering first aid treatment, he was referred to SVRRG hospital. After 3 days of treatment, inpatient treatment, he was referred to DBR Hospital, Tirupati, and thereafter to Glen Eagles Global Health City Hospital, Chennai, where he took treatment as inpatient from 5/1/2018 to 10/1/2018. Despite the above said treatment, he was further admitted to Bird Hospital, Tirupati, and underwent amputation of the left leg above knee. During the course of treatment, the claimant expended about 6 lakhs of rupees towards medicine, treatment, conveyance, nourishment, other incidental expenses. Due to the injuries sustained in the accident, the claimant had to undergo amputation of the left leg above the knee, due to which he has encountered permanent physical disability, thereby sustaining enormous financial loss, irreparable emotional and mental ability to sustain the same, and the trauma and the pain having undergone during this period of treatment. Full stop. To state it, claimant was hale and healthy prior to the occurrence of accident. He was working as a contract labor in Landco Industries, Srikalahasti, Andhra Pradesh, earning around 15,000 per month. Due to the amputation of his left leg above the knee, claimant has lost his future earning capacity due to his permanent disability. In view of the same, for having incurred severe financial expenditures and mental and emotional distress and pain and trauma, he filed a claim petition seeking compensation against the respondent. Respondent number 1 remained absent despite service of notice. Respondent number 2, insurance company, filed a statement of objections, admitting the policy of insurance with the lorry, however, denied that the negligence was be attributed against the driver of the lorry, and pleaded that the accident occurred due to the negligence of the claimant himself, as he had consumed alcohol and was riding the motorcycle. It is also pleaded that there's a delay of 20 days in lodging the FIR, and on this basis, he sought for dismissal of the claim petition. Based on the pleadings, Tribunal framed relevant issues for consideration. Please sit down, sir. Relevant issues for consideration in order to establish the case and prove same. Claimant examined himself as PW1, got marked exhibits P1 to P14. Examined the doctor as PW2, got marked two documents through the doctor as PW15 and 16. Whereas respondent number 2, insurance company, examined its official as RW1, got marked the policy as R1. On the basis of material evidence, both oral and documentary, and on hearing the submissions of learned counsels for both parties, Tribunal awarded a total compensation of 9,48,000. Fastened the liability against the insurance company and directed the same to pay within a period of 60 days. The claimant, being dissatisfied with the inadequate and meager compensation awarded by the tribunal, is before this court seeking enhancement. It is the vehement contention of learned counsel for the appellant claimant that the tribunal has committed a gross error in not taking into consideration the materials placed, and is also not assessed the proper income for awarding suitable compensation. It is also contended that the tribunal has committed gross miscarriage of justice by not appreciating the materials on record, considering the present facts of the case, where the claimant has lost his left leg above the knee due to amputation and has not taken the disability as 100%, despite the Dr. PW2 opining disability to an extent of 80%. The tribunal assessing the disability to the whole body at 20% is grossly erroneous. The same requires to be modified, and 100% disability is required to be taken in the present case on hand. It is further contended by learned counsel that the tribunal has not awarded suitable compensation under other heads. Thereby, the tribunal has committed an error in awarding total compensation to the claimant. Hence, he seeks to allow the appeal and consequently enhance the compensation. Full stop. Per contra, learned counsel representing the insurance company vehemently contends that the tribunal has awarded just and reasonable compensation based on the materials placed on record, and he contends that no interference is called for at the hands of this court. He further contends that the assessment of income is made by the tribunal as no proof of income is produced. So also the multiplier is correctly taken by the tribunal, which does not call for interference. He also contends that under other heads like prosthetics and future medical expenses, pain and suffering, loss of amenities, tribunal is awarded just and reasonable compensation. So thereby, the award of compensation does not call for interference, and enhancement is not called for in the present case. On these grounds, he seeks to dismiss the appeal referred by the claimant. I have heard learned counsel for the claimant and learned counsel for the respondent insurance company. It is not in dispute that on 1/1/2018, when the claimant was riding his Honda Unicorn motorcycle, he met with an accident wherein the lorry dashed against the motorcycle of the claimant, leading to the crush injuries of the left leg of the claimant, due to which the left leg above the knee came to be amputated after enormous amount of medical treatment to save the leg. The fact remains that the claimant's left leg above the knee has been amputated. Though the claimant has stated that he was earning 15,000 per month working as a laborer in Lanco Industries, Srikalahasti, no documentary evidence has been placed in proof of the income. Under such circumstances, when there is no proof of income, the tribunal as well as this court are left with no other remedy but to rely on the Legal Services Authority chart, which is taken as a basis for computation of income. The chart prescribes an income of 12,500 for the accident year 2018, whereas the tribunal has assessed the income of 9,000. The same requires to be enhanced to 12,500. The claimant was aged 25 years as on date of occurrence of accident. The appropriate multiplier would be 18, which is correctly taken by the tribunal, which does not call for interference. Full stop. The doctor PW2 has adduced evidence who has stated there is that evidence of doctor, which page it is, that 80% and in the judgment 40. The doctor has assessed the disability to an extent of 80% to the whole body. Being permanent disability to the whole body. Full stop. However, the tribunal, on examining the evidence adduced by the doctor, despite the evidence of the expert, has taken the disability to an extent of, has reduced the disability to an extent of 20% to the whole body. I am in agreement with the learned counsel for the appellant claimant that the reduction of the disability to 20% by the tribunal, ignoring the evidence of the expert, Dr. PW2, which says 80% to the whole body, is grossly erroneous, as the tribunal cannot sit over the judgment and opinion expressed by the doctor who is an expert in the field of medicine. It's a different matter that the doctor who has given the opinion is or adduced the evidence is not the treated doctor. However, once he is an orthopedic surgeon, the fact remains that there is an amputation of the left leg above the knee. That itself is sufficient to prove the fact that the claimant has lost one left leg above the knee, which should clearly depict the permanent disability to an extent of 80%. Even if it is not 80%, when the disability is over and above 30 to 50%, it should be taken as 100% for the purpose of functional disability. Under the circumstances, the tribunal is left with no other alternative but to award future prospects in such cases. In the present case on hand, tribunal has not awarded future prospects considering the disability to be 20%. Full stop. Hence, the loss of future earning capacity, future earnings due to disability would be 1,500. Have you done the calculation? So 12,500 plus 40%. So 17,500 into 12 into 18. Be 37 lakh 80,000. Correct? Be 37 lakhs 80,000 as against 3,89,000 awarded by the tribunal. The tribunal is awarded rupees 1,43,000 towards medical expenses, treatment and transportation on the basis of bills produced, which does not call for interference. So also during the period of treatment, food, nourishment and miscellaneous expenditure is awarded at 30,000. Same does not call for interference. Towards loss of earnings during the period of treatment, this 36,000 is awarded. Same is also not interfered. Towards prosthetics and future medical expenses, tribunal is awarded 2 lakhs, which does not call for interference. Towards pain and suffering, trauma and consequences, tribunal is awarded 1 lakh. Same is also not interfered. Towards loss of amenities and future marriage prospects, tribunal is awarded 50,000. You are not aware whether he is married or not married. Leave it at that. No, I'll leave it at that. But have you stated anywhere? Loss of amenities, loss of marriage prospects. 50,000 is awarded by the tribunal. Deem it appropriate to award rupees 2 lakhs under this head. Towards pain and suffering, 1 lakh is the number. Otherwise, you say that this court deems it appropriate to award 1,50,000 under this head. Anything else? This case which you relied is also exactly the similar. Here also amputation of the leg above the knee. 37 lakhs 80 lakhs. Loss of amenities is put together. How much is given? Loss of amenities is put together.
2 lakhs.
2 lakhs. Future marriage expenses, huh?
That's all.
And future marriage expenses.
1,50,000 on relevance.
Hmm.
Loss of amenities and future marriage prospects. Tribunal has awarded 50,000. I deem it appropriate to award 2 lakhs and that. And pain and suffering,
150.
1,50,000.
In view of the above discussion, one more paragraph about it. As learned counsel for the appellant claimants relies on the judgment of the Honorable Apex Court in the case of Irudhaya Priya versus State Express Transport Corporation Limited, reported in AIR 2020, Supreme Court 4284. Wherein in similar circumstances of an amputation, this court has awarded future prospects and the marriage loss of marriage prospects, which is applicable to the present case of the case, which is applicable to the present case. In view of the discussions made here and above, the claimant would be entitled to total compensation of 45 lakhs 39,000 as against 9 lakh 48,000 as mentioned in the table below. Accordingly, I pass the following order. Appeal is, how much was the claim made by you? What is the claim petition? Claim petition first page original claim petition one. Claim petition.
30
Huh?
30 lakhs. 30 lakhs.
Appeal is allowed. Judgment and award is passed by the so-and-so and so is modified. Claimant is entitled total compensation of 45 lakh 39,000 as against 9 lakh 48,000. Along with interest. Stop. As stipulated by the tribunal. Full stop. Enhanced compensation shall be paid by the insurance company with interest at 6% per annum within a period of 6 weeks. All other terms stipulated by the tribunal stands intact. Yes. There may be slight variation in calculation. I don't know. I will check up again and ask it. Calculation only.
Prospects 45. And 100%. Very good. Very good. ಅದು ಎರಡು ತಗೊಳಪ್ಪ Future prospects 40% time money plus 100% disability. Disability 100% considered.
Number 52 adjourned, 53. Not pending.
ಯಾರು? You're there in connected matter. Not listed today. You have filed that? In that you have filed wakalat. Which is that appeal? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ appeal number? ಕೇಳ್ತಾ ಇರೋದು registry list MFA number. Okay, 21 along with this appeal. You will take notice for R2. Learned Counsel Ravish Benny is directed to take notice for R2 registry to show his name in the cost list. Relist next week. Copy kotra. Counsel for the appellant to furnish one set of copy to the respondent number 2 counsel.
54. Sahadev Reddy DN.
Next week. There is no representation on behalf of appellant. Counsel for R2 is present. Relist next week.
55. Girimalaya.
Yes, Mr. Girimalaya. Yes, any settlement between both of you? No.
Doctor says the disability is kind of an ambiguous statement made by the doctor in his evidence. The disability to right upper limb is 23%. And the tribunal has taken this because when it comes to both bodies, 1% has been taken, 7% has been taken by the right. But now I go through the sentence. This said that total body permanent disability from right upper limb. This is the statement. Common reading indicates the disability to the right upper limb is 23%. But here there is one word that is important.
Total
body. So whether it is total body means the whole body or the limb.
So he, Dr. PW2 says 23%.
23%.
No, what is the disability? What is the injuries?
He had got fracture, radius fracture, and humerus fracture. And radius, it is not a radius complete fracture. There is a small bone called electron at the elbow joint. That end of radial head in fracture. And there is a fracture of ulna and humerus fracture.
In addition to this, there was a degrowing injury.
Yes, undergone wound
Degrowing injury from elbow and dura.
So that cannot be 25% whole body agata. 23 whole body agata.
He cannot move his right hand, he cannot use his right hand. Condition of the patient.
What was his avocation?
Loading and loading.
Labor.
It was referred to local. Since there was a deformity, abdominal deformity, in a local they cannot take the disability on the higher side. Therefore, we have referred back.
So what should be taken?
Only 7% is taken.
So that the tribunal is done because the doctor has said whole body above the upper limb.
Yes. As the sentence should be total body permanent disability from right upper limb is
Find a discussion
20%.
16 of the judgment.
16 of the judgment.
16 and page 30, internet page 13.
Yes, you read it.
Then read it with the nature of the injuries from para 15.
15 injuries.
Any one of you can read.
In this case of the prisoner that are about the actually sustained previous injury, in order to prove his contention, the prisoner produced PA wounds issued by the Sanjay Gandhi Institute of Trauma and Orthopedics, and it discloses that prisoner sustained number one, decoying into elbow to right for arm reason, and excess was committed left polygon and radial end with supracondylar fracture of humerus, close left ulnar distal one-third soft fracture, feet or a left molar, and the cartilage opened the beginning of the village. Exit P9 or the two discharge signal institute by the Sanjay Gandhi Institute of Trauma and Orthopedics, and they have disclosed that the prisoners trained. Prisoner was diagnosed with type 3B open supracondylar fracture humerus with broad glass, dominant fracture of one column with radial head, closed left ulnar distal one-third soft fracture. The PT or left forearm further during his inpatient treatment in the state hospital from 17/4 to 18/4 to 18 for a period of 18 days. Prisoner has undergone different and external fixation application and close reduction implication plus 9 for ulnar, different and SSD. Another discharge on the disclosure that the prisoner has taken a treatment as an inpatient in the same hospital from 4/6/2018 to 7/6/2018 for a period of 3 days, and has undergone surgery for lower external fixation. In all, the prisoner has taken an inpatient for a period of 22 days. Therefore, the range of the gravity of injury sustained by the prisoner, the procedure undergone, and duration of the treatment taken, I award some of this 15,000 payments regarding disability connection. It is the case of the prisoner that due to the accident, he has suffered the permanent disability. In order to receive prisoner examined Dr. 48, working as a orthopedic, professor of orthopedic art, SITO, Bengaluru, as PW2, in his evidence filed in lieu of his examination. In PW2 has given a detailed descriptions of the injuries sustained by the prisoner, and in the line statement given to him, further he has stated that he has examined the prisoner clinically and radiographically on 15/10/2019, and as the disability has for the guidelines, and that the overall total permanent disability from right upper limb is 23%, and stated that the disability is permanent in nature, and with this disability, prisoner quite difficulty to do manual work, and further to admissions records at exhibit P30 and P40, the excess of P15. This is the case. The tribunal has taken only 7%. Is our request. Taking the consideration next major outcation, tribunal has been taken. That's the loss of return. The accident happened in the year 2018. Income taken by the tribunal is 10,000 instead of 12,000.
Yes, true.
10,000 is taken.
10,000.
12,000.
Accident of the year?
2018.
So it should be 12,500 or 12,000?
And even payments criminal. Taking the number of fractures, the people are awarded is about 50,000 yesterday. Same is required for. And the loss of money will depend on credit. 4 months is considered.
Medical expenses, correct?
As the bills.
Loss of income will change.
40,000 is awarded.
4 months.
10,000 per month. Taking into consideration gravity of the injury, 6 months is to be considered. For instance. And future loss of amenities. Only 25% awarded. Then the accident was 27 years old. Road living life that is very good.
That's all.
Also, incidental expenses about the website.
Yes.
Specialized payments that keep even the portion my current friend right now, he has undergone surgery only for the fracture of nice concept. Rest of the fractures were treated with a POP task. And there is a wound every but amputation was in inpatient for a period of 22 days. Already conveyance and nourishment is granted to the extent of 25, which is more than the number of days. And the payments of 50,000, it's a Allah fracture, another fracture is small bone, which is liver or joins this elbow joint. And which was treated, and there is also the implants that is being removed, which is being stated in the evidence. As far as the amenities, some portion can be granted, 25,000 is granted with it. And loss of future earning capacity cannot, it cannot be considered because the doctor who deposed us is not a doctor who treated him. He has examined him and deposed only to the extent of assessment of disability. And even in this entire evidence affidavit, he doesn't say that whether the fractures are related and calibrated, nothing forthcoming from the complete reading of the affidavit. So that 23% disablement as stated by the doctor cannot be considered. So, yes, I do agree that whatever the tribunal is considered at 6% is on having regard to the ratio of the injury, is on it's inappropriate. But to the extent of 23%, maybe to that.
What should be awarded according to you? It will not go on record anyway. What, Mr. Girimalaya? Which will not go on record. What should be awarded?
20% can be considered. Because I want to be fair, you say that.
They have suggested that you are not, it is past, so then personally I have not treated it. Is the data. Not only a half accident, there was a fracture of numerous and going in deep way. You cannot know in when motion is right.
Whether any photographs are produced?
No.
Not produced. All right. I'll dictate in the afternoon.
May I make a request, my lords?
Yes.
Next matter, serial number 56, my lords. I have some health issue. Would my lord kindly take it next week?
Yes. At request of counsel for the corporation, Allah.
Please, my lords.
Corporation release this matter next week. So Mahadev Swami is here. You are appearing in 56. Release next week.
Please, my lords. Please.
Yes.
More blessed.
50.
58 dollars out of this injury. That's local tagged ಬೇರೆ 3 ಕೇಸ್ ಹೋಗ್ತಾರೆ.
You are appearing in all. In all 4 cases, you are appearing. At request of learned counsel for the insurance company. Release next week. 70. ಚೆನ್ನಾಗಿದೆಯಲ್ಲ
May I make a mention, my lords?
66. Shivanna Gowda. You are for? Shiv Kumar. What do you want? At request of learned counsel for respondent number 2. Release next week.
May I make a mention, my lords?
Yes.
Serial number 57, my lords. For the appellant corporation, my lords. I seek for a week's accommodation, my lords.
Learned counsel for the appellant seeks time. Release next week.
Grateful, my lords.
ಓಪನ್ ಮಾಡ್ದಮ್ಮ. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 70 ಅರ್ಜೆಂಟ್ ಕೇಳಿದ್ರಮ್ಮ.
70 ಇಲ್ಲ ಸರ್.
ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ? ಸರಿ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು ಅಮ್ಮ, ಥ್ಯಾಂಕ್ ಯು.
This is so much. I don't know. Let's see, Akish. Request of learned counsel for appellant. Read this next week. 70? Ah. Request of learned counsel for the appellant released next week. Yes. 1 minute. In which case, madam? What do you want?
Last.
We got 70. 3 years less, 80%. There is application one day.
What has happened here? Oh, it should have been into 80%. Other Madila. That must be child. I use your talking. I use case must be child case. It's a case of permanent disability and I think paraplegia or something. See, if it is a case of paraplegia or vegetative state, then it is as good as a death case. Their disability will not come. It is 100%. In this case, it would have to be into 80%. Correct. So other.
776, managed prospects has been given 3 lakhs.
In marriage expenses.
Marriage prospects.
Marriage prospects. Here we have given. Il kottevalla niಮಗೆ. ಇಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದೆ 2 lakhs. No, in your case, I think I have awarded 2 lakhs marriage prospects. So you are saying it should be 3 lakhs. Para
28.
Kajal's case.
Kajal case. So there, the facts and circumstances were different amounts. Even there, she was totally vegetative state.
Literally, she became vegetative.
All these aspects are being considered.
See, it all differs from case to case. So here, in Kajal's case, brain, I think, with a brain of 9-year-old child, then she will, apart from all that, she will need 2 other persons' attendance. That also, some of the judgments of the Supreme Court has calculated with multiplier. So that is not the case here. He doesn't need 2 other persons in this case. He will probably, that is why he will need prosthetics. He will need marriage prospects. He will be treated with 40% future prospects of 80% disability and amenities, pain and suffering. So little modification I will do. So whatever you want to say, you just put it in a piece of paper, A4 size, you give it. I will pass that on. Huh? Yes. I think into 80% is left out. Oh.
Into 100 was taken.
Into 100 was.
Yes, both the legs.
Illa.
Because the loss of 1 leg.
1 leg. 1 leg above, left leg above the knee. $57 lakhs 80,000 ಆಗಿದ್ದು into 80% agri. Become 30 lakhs 24,000. Yes, madam. Thank you for assisting.
Fine. Himalayan.
Yes, Vijay.
One the pass.
Now this is number.
44.
This I think I am dictating. I heard you. I'll take up after this. If you have serial number, you. Huh? So the question of disability of whether 23% or anything else. So have you cross-examined the doctor?
Yes, I see. The doctor looks into the evidence, it's fine with the doctor. As far as the range of movements is concerned, the airport joint and wrist joint, he says there is small restriction for that. As far as the stability component is concerned, he says it is all normal. There is no disability as well as stability component. So, in regard to this fact as well, the disability assessed value at 23%. It is at higher. And even the fact that he has undergone surgery only for unlimited, not for other factors. And irrespective of the fact that the doctor stated that it is not the facts. And it is not the case with the doctor that there is a manual practice of not denied.
Moreover, disability is with regard to physical disability.
Yes, so it's not a functional disability. That is
So what is the avocation of that person?
Loader.
Loader.
He was very clever.
All right. But 7.6% is on the lower side.
yes, this that I can perceive.
Records are available or not available? You have the evidence of doctor?
Yes. Page 2. A1. The report on owner, as regards the range of movements of 0 to 140 dB, there is a restriction to the extent of 40 dB, then good mind, 40 at the owner. And next, your losses comes to stability component. All the joints are normal. There is no restrictions for them. And he has not small some relative be as far as lifting the objects over it and keeping in an Indian state. That's what says in the assessment coordinated act.
There was a bone loss.
29 and T10 pertaining to the period that there is no recital regarding the wound loss. And except saying that there is a wound loss, there is no detailing mention as to what is the extent of loss, where it is being lost. They say it's lost to humerus fracture, but it is not forthcoming on a plain reading of the evidence certificate of it.
It is true that the fractures are united. But why can't you take some second opinion and produce it before the tribunal or this court? Because I am not an expert, neither are you. Now, if I am doing it on a guesswork of either 15% or 18%, I think we may not be doing a precise job with regard to the disability. We are only doing to satisfy either of you. Honestly, because neither the tribunal nor me nor you, we are not expert in this. So the best thing would be for insurance company to provide a second opinion. So based on these two opinions, at least an average can be taken or a board can be taken or cross-examined. Though he has stated that there is no fractures. I mean, fractures are united, but there could be some disability. Working disability could be there. So may not be to the extent of. That's what should be done in all the MVC cases, but none of the insurance company does it. We are only arguing in the appeals court.
When it comes to any review and cognitive disability, usually an application will be made to refer the parties to the non-medical board. There are second opinion will be sought. But usually a case of this nature there are fractures. It are done on a guesswork.
That is what that guesswork is again. Not a foolproof guesswork. It is only.
It may result in a windfall and
because we are thinking on a mathematical calculation. But a person who has undergone the disability, he will not be able to, if he is not able to do any other work, then he is on the losing side. So that is the only point for discussion, huh? Disability. So income 12,500 for the chart. 12,500.
The amenities.
And the multiplier is 17.
Last 3%.
Because during later period, 18 days he was in prison. 3 months if it is taken 12,500. 38 months.
4 months is the 2 days he was inpatient.
22 days he was inpatient, 25,000 is given.
22 days he was inpatient.
That's per court. Appeal is preferred by the claimant. Challenging the judgment and award of the Court of Small Causes, MACT, Bengaluru, SCCH1, in MVC number 3399 of 18, dated 17 February 21. Please sit down. The appeal is founded on the premise of inadequate and meager compensation awarded by the tribunal. 3 facts. The claimant was traveling in an ambulance carrying KA447934 from Tiptur to Bengaluru, along with a patient on 6/4/2018. When the ambulance reached Konana Kaval, Puttur Taluk, the driver of the ambulance drove the same in high speed and in a rash and negligent manner, due to which the ambulance got turtled. Due to which the claimant sustained grievous injuries. The claimant was immediately shifted to government hospital, Puttur, where he was provided first aid treatment, and thereafter shifted to Sanjay Gandhi Institute of Trauma and Orthopedics, where he underwent surgery, external fixation, and skin grafting. It is the contention of the learned counsel. It's the further pleadings that the claimant was involved in labor work of loading and unloading and earning a sum of rupees 15,000 per month. Due to the accident, claimant has suffered permanent disability and he is unable to do his work as he was prior to the occurrence of accident, thereby causing him loss of financial growth, so also mental and emotional distress and pain and agony. Hence, the claimant filed claim petition seeking compensation. Respondents filed the statement of objections, denied the age avocation income, and the claim that there was negligence on the part of the driver of the ambulance. And contended that the accident had occurred due to the mistake of the claimant, who was interfering with the job of the driver while taking turns. Hence, on this basis, sought for dismissal of the claim petition. On the basis of pleadings, Tribunal framed relevant issues for consideration. In order to substantiate the issues and establish his case, claimant examined himself as PW1, another witness as PW2, and got marked exhibits P1 to P15. Whereas respondents did not lead any evidence nor mark any documents. On the basis of evidence, both oral and documentary, the tribunal granted a total compensation of 2,99,000 and directed respondents by ordering the respondents 1 and 2 to be jointly and severally liable to pay the compensation. Directed respondent number 1 to indemnify respondent number 2 to pay the compensation within 2 months. Agreed by the meager compensation awarded, claimant before this court. It's the vehement contention of learned counsel for the appellant claimant. The tribunal has committed an error in not awarding suitable compensation. Tribunal has also failed to take into consideration the opinion expressed by the Dr. PW2. who had opined disability to an extent of 23%, whereas 23% of the whole body, 23% to the total body permanent disability from right upper limb 23%. However, since the whole body disability was not stated in specific manner, Tribunal has assessed the disability to be 7.66%.
Appellant contention.
It is further contended by learned counsel for the appellant that the Tribunal has committed an error in not awarding suitable compensation on other heads, including loss of income during later period, loss of food towards food, nourishment, and tenant charges during treatment, towards loss of amenities, and towards other miscellaneous expenditures. On these grounds, he seeks to allow the appeal and consequently enhance the compensation. Full stop. Per contra, learned counsel representing the insurance company vehemently contends that there is no illegality or arbitrariness in the award passed by the tribunal, which calls for interference of the hands of this court. Learned counsel further contends that the tribunal has taken the notional income of 10,000 for the reason that the claimant has not produced any cogent material or proof of income. Thereby, the notional income is rightly adopted by the tribunal, which does not call for interference. Stop. He further contends that the claimant is stated to be 23 years old. The appropriate multiplier of 17 is correctly taken, which does not call for interference. So also, he contends that the evidence adduced by the doctor, having opined 23% as disability to the whole body may not be correct, which is rightly appreciated by the tribunal and has divided the same towards whole body disability by adopting the notification methodology and has arrived at a disability at 7.66% as against 23%, which also does not call for interference. He further contends that under all other heads, tribunal is awarded just and reasonable compensation. Hence, there cannot be any interference in the reasonable compensation awarded by the tribunal. On these grounds, she seeks to dismiss the appeal. I have heard learned counsel for the appellate and counsel for the respondent. It's not in dispute. An accident occurred on 6/4/2018 when the claimant was traveling in the ambulance. Due to the negligence and high speed of the driver of the ambulance, the claimant suffered certain injuries and he was provided treatment due to the said injuries sustained in the due to the negligence of the driver of the ambulance offending the vehicle. Claimant has met with financial expenditures and has incurred physical disability. To establish these aspects, claimant has produced exhibit P1 to P8, the police records, which would indicate that the FIR is filed against the driver of the ambulance in the charge sheet has been also laid against the driver of the. These aspects are not disputed or controverted or challenged by the driver of the said vehicle. Hence, negligence is rightly attributed as against the driver of the ambulance. Secondly, the documents are produced at P9 to P15, which are medical records, to prove the financial expenditures met during the course of treatment and the bills for the same. Full stop. Now, coming to the question of age, avocation, income, and the disability that is requires to be assessed. The age of the claimant is 23 years. The appropriate multiplier is 17. Same is not interfered. The Dr. PW2 has assessed the disability to an extent of 23%. On perusal of the evidence of the doctor, it is stated that
Age of 7 years and 24 of the judgment.
20. Then he's not 20. So he's not 22, 27 years.
Yes.
But you said 23. Yeah. 27. Age 27 years. The doctor has stated on oath that there is degloving injury of the left elbow to the left forearm region. And the X-ray shows comminuted left olecranon and radial head with SC fracture humerus, closed left ulnar distal 1/3 shaft fracture. And there is a type 3B open SC fracture humerus with bone loss comminuted fracture. The doctor has opined that the injuries are grievous in nature and arrived at a disability to an extent of 23% towards total body permanent disability from right upper limb to be permanent in nature. The tribunal, not believing the version of the doctor as it is not convincing, reduced the disability to 7.66%. I'm afraid the assessment made by the tribunal may not be correct, as the tribunal cannot drastically reduce the disability without there being any basis to the contrary to the evidence adduced by the doctor who is an expert in the field of medicine. Though the doctor has not specifically stated whole body disability, but has stated whole body, total body permanent disability from right upper limb to be 23%. In the facts and circumstances of the case, considering the age and avocation and the nature of job performed by the claimant, this court is of the opinion that at least 18% disability of functional disability can be taken for consideration in the present case on hand. As it should act as this court or the tribunal should not be in a position to assess the proper disability unless the contra material evidence is placed on record. So time and again, this court has held that when there is a evidence adduced by the doctor, to controvert the same, the insurance company should take second opinion if they are controverting the percentage of disability, or in the alternative, at least refer the matter to the board if there is drastic variation with regard to the disability. But the same is not done in most of the cases by the insurance company, leaving it for guesswork to the tribunal and this court. However, as a method of trying to analyze the functional disability on the basis of evidence adduced by the doctor, this court would have to consider what would be the disability for the claimant to perform his future activities and what would be the loss of income. Hence, 18% would be reasonable under the present facts. The income of the claimant is taken at 10,000 per month by the tribunal as there is no cogent proof of evidence, cogent proof of income placed by the claimant. However, the notional income chart described by the Legal Services Authority for the accident year 2018 describes 12,500 per month. Same is taken on hand in the present case for computation. The multiplier is rightly applied, the same is retained. Hence, the loss of future earning capacity due to disability would be 12,500 into 12 into 17 into 18. 4,81,950. Correct. 4,59,000. As against 1,42,800 awarded by the tribunal. Towards medical expenses, actual amount has been awarded which does not call for interference at 15,964, same is retained. Towards pain and suffering, tribunal is awarded 50,000. An additional 20,000 is awarded under this head. Towards loss of income during later period, in view of this court enhancing the income per month to 12,500 into 4 months, 50,000 is awarded as against 40,000. Towards food, nourishment, conveyance, attendant charges, 25,000 is awarded. Claimant was inpatient for 22 days. An additional 10,000 is awarded under this head. Towards loss of amenities, tribunal is awarded 25,000. An additional 15,000 is awarded under this head. In view of the above discussions, the claimant would be entitled to total compensation of dash as against 2,99,000 as per the table below. Accordingly, I pass the following order. Appeal is allowed in part. Judgment is modified. Claimant is entitled to total compensation of dash as against 2,99,000. Interest awarded by the tribunal is retained. Enhanced compensation shall carry interest at 6% to be paid by the insurance company within a period of 4 weeks from the date of receipt of copy of the order. Madhukara? Food nourishment is total.
Food and nourishment is funded.
Totally comes that 19,000.
Food and nourishment is total.
Food and nourishment, 25,000. That it is 40,000.
Australia, 6 lakh.
19,964.
I'm getting 6,24,964. You are getting 6 lakhs?
19,000.
19. Now, did you add the medical expenses? Okay, do that calculation.
Yes.
4 weeks. And all other amount is paid?
50% of the amount.
The entire enhanced amount shall be dispersed and paid to the claimant upon proper verification. Yes.
Number 44, pass-through matter.
Yes, Mr. Gurudev, you are ready, Allah?
There is involvement of the victim and also
Involvement of vehicle?
negligence. And also
Quantum. That is his appeal.
Yes.
So according to you, your vehicle was not at all involved. So it's a fake case.
Yes. Yes. Absolutely.
FIR is filed against you, I think. No. Initially against unknown vehicle, later on your vehicle is implicated. Yes.
From 16/6/2016.
1610. 1610.
16/10/2016. At about 2 a.m. at night. The alleged accident. According to the patient, the deceased, after parking his car, bearing registration number A03AB 9526 on the edge of the road at Bhima Relevance, when he was crossing the outer ring road, but at that time, an unknown car came and dashed against him and hit him and died from the place. Action was taken within the midnight. Nobody was there. Thereby, the driver of the car sustained injury and died on the spot. But the complaint was given.
So he was a pedestrian at that time.
At the time, it's
walking.
Yes, but he said he parked his car and went he died.
So that is the complaint before the police also? Who was given the complaint?
Father of the deceased. Admittedly,
When was the complaint given?
in the police station.
Yaವಾಗ?
And
Same day. Same day.
Same day, almost the same day, by 9 a.m. 9 a.m. I read the complaint. Complaint is father of the accused. Admittedly, he is not an eyewitness. He was not the driver. He has not seen. Anything come back. ವಿಷಯ ನನ್ನ ಮಗ ರಂಜಿತ 24 ವರ್ಷ ಅವರಿಗೆ ಅಪಘಾತ ಮಾಡಿ ಪರಾರಿಯಾದ ಅಪರಿಚಿತ ವಾಹನ ಚಾಲಕನ ವಿರುದ್ಧ 200 ನಡೆಯುತ್ತಿರುವ ಬಗ್ಗೆ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ 16 ಬೆಳಗಿನ ಜಾವ 8:30 ಗಂಟೆಯಲ್ಲಿ ಬಾಲಸ್ವಾಡಿ ಸಂಚಾರ ಪೊಲೀಸ್ ಠಾಣೆಯಿಂದ ನನ್ನ ನಂಬರಿಗೆ
because they were informed by the police to the father to come to get justice. ಕರೆ ಬಂದಿತ್ತು ನನ್ನ ಮಗ ರಂಜಿತ್ ಅವರಿಗೆ ಅಪಘಾತವಾಗಿದ್ದು ಕೂಡಲೇ ಠಾಣೆಗೆ ಬರಲು ತಿಳಿಸಿದಂತೆ ನಾನು ಠಾಣೆಗೆ ಬಂದಾಗ ನನ್ನ ಮಗ ಟೊಯೋಟಾ ಇಟಿಯೋಸ್ ಕಾರ್ ಕ್ಯಾಬ್ ಕಾರ್ K03AB 9526 ಠಾಣೆ ಬಳಿ ನಿಂತಿತ್ತು. ಅಟ್ ದ ಟೈಮ್ ದ ಕಾರ್ ಇಸ್ ಬಿಫೋರ್ ದ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್. ಠಾಣೆ ಬಳಿ ನಿಂತಿತ್ತು. ನಂತರ ನನ್ನ ಮಗನಿಗೆ ಏನಾಯ್ತು ಅಂತ ವಿಚಾರಿಸಿದಾಗ ರಾತ್ರಿ ಕರ್ತವ್ಯದಲ್ಲಿ ಇದ್ದ ಪೊಲೀಸರು ತಿಳಿಸಿತ್ತು ಏನಂದ್ರೆ ಈ ದಿನ ಬೆಳಗಿನ ಜಾವ ಸುಮಾರು 2 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮಗ ಆತನ ಕ್ಯಾಬ್ ಅನ್ನು ಹೊರ ರಿಂಗ್ ರೋಡ್ ರಸ್ತೆ ಭೀಮಾ ಜ್ಯುವೆಲರ್ಸ್ ಎದುರು ನಾಗವಾರ ಕಡೆಗೆ ಹೋಗುವ ಮಾರ್ಗದಲ್ಲಿ ರಸ್ತೆ ಅಂಚಿನಲ್ಲಿ ನಿಲ್ಲಿಸಿ ಯಾವ ಕಾರಣಕ್ಕೂ ಸದರಿ ರಿಂಗ್ ರಸ್ತೆಯಲ್ಲಿ ಹಾಗೆ ಮುಂದೆ ನಡೆದುಕೊಂಡು ಹೋಗಿ ಫಾರೆಸ್ಟ್ ಆಫೀಸ್ ಎದುರು ಇರುವ HDFC ಬ್ಯಾಂಕ್ ಎದುರು ಸದರಿ ರಸ್ತೆಯನ್ನು ದಕ್ಷಿಣದಿಂದ ಉತ್ತರಕ್ಕೆ ರಸ್ತೆ ದಾಟುವ ಮಾರ್ಗದಲ್ಲಿ ಇರುವ ಸೆಂಟರ್ ಮೀಡಿಯನ್ ಪಕ್ಕದಲ್ಲಿ ಅಂಗಾತವಾಗಿ ರಸ್ತೆಯ ಮೇಲೆ ರಕ್ತ ಗಾಯಗಳಿಂದಾಗಿ ಬಿದ್ದಿದ್ದಾಗ ಅಲ್ಲಿಯೇ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಹಾಗೂ ಸಾರ್ವಜನಿಕರ ಸಹಾಯದಿಂದ ಪೊಲೀಸರೊಂದಿಗೆ ಮಾಹಿತಿ ಕೊಡಿಸಿ ಸ್ಥಳಕ್ಕೆ ಕರೆದುಕೊಂಡು ನಂತರ ಸ್ಥಳದಲ್ಲಿಯೇ ತಲೆಗೆ ತೀವ್ರತರವಾಗಿ ಗಾಯಗೊಂಡಿದ್ದ ನನ್ನ ಮಗನನ್ನು 108 ಆಂಬ್ಯುಲೆನ್ಸ್ ನಲ್ಲಿ ಡಾಕ್ಟರ್ BR ಅಂಬೇಡ್ಕರ್ ಆಸ್ಪತ್ರೆ ಶವಾಗಾರಕ್ಕೆ ಕಳುಹಿಸಿದ್ದಾರೆ ಎಂದು ತಿಳಿಸಿದರು. ಅನಂತರ ನಾನು ಅಪಘಾತಕ್ಕೆ ನಡೆದ ಸ್ಥಳಕ್ಕೆ ಪೊಲೀಸರ ಜೊತೆ ಹೋದಾಗ ರಸ್ತೆಯಲ್ಲಿ ಬಿದ್ದಿದ್ದ ರಕ್ತದ ಕಲೆ ಹಾಗೂ ವಾಹನದ ಹಿಟ್ ಮಾರ್ಕ್ಗಳನ್ನು ಗಮನಿಸಿದಾಗ ಹಾಗೂ ನನ್ನ ಮಗನ ಮೇಲಿದ್ದ ರಕ್ತ ಗಾಯಗಳು ಹಾಗೂ ತರಚಿದ ಗಾಯಗಳಿಂದ ಹಾಗೂ ಸ್ಥಳಕ್ಕೆ ಬಂದಿದ್ದ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಅವರ ಹೇಳಿಕೆಯಂತೆ ನನ್ನ ಮಗ ರಂಜಿತ್ ಅವರು ರಸ್ತೆ ದಾಟುತ್ತಿದ್ದಾಗ ಸದರಿ ರಸ್ತೆಯಲ್ಲಿ 800 ಕಡೆಯಿಂದ ನಾಗವಾರ ಕಡೆಗೆ ಬಂದ ಅಪರಿಚಿತ ನಂಬರ್ ಗೊತ್ತಿಲ್ಲದ ವಾಹನ ಚಾಲಕ ತನ್ನ ವಾಹನವನ್ನು ಅತಿವೇಗ ಹಾಗೂ ನಿರಾಗರೂಕತೆಯಿಂದ ಚಲಿಸಿಕೊಂಡು ಬಂದು ನನ್ನ ಮಗನಿಗೆ ರಭಸವಾಗಿ ಡಿಕ್ಕಿ ಮಾಡಿದ್ದರಿಂದ ಡಿಕ್ಕಿಯಾದ ರಭಸಕ್ಕೆ ನನ್ನ ಮಗ ರಸ್ತೆ ಮೇಲೆ ಬಿದ್ದಾಗ ತಲೆಗೆ ತೀವ್ರತರವಾದ ಗಾಯಗೊಂಡು ಸ್ಥಳದಲ್ಲಿಯೇ ದೃಢವಾಗುತ್ತದೆ. ಈ ಸಸ್ಪೆಂಡ್ ಹೆಡ್ಡಿಂಗ್ ಸದರಿ ಅಪಘಾತ ಮಾಡಿ ಪರಾರಿಯಾದ ಪರಿಚಿತ ವಾಹನ ಚಾಲಕರನ್ನು ಪತ್ತೆ ಮಾಡಿ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಕೋರಿದೆ. ಭೀಮಾ ಜ್ಯುವೆಲರ್ಸ್ ಮುಂಭಾಗದಲ್ಲಿ ನಿಂತ ತನ್ನ ಮಗನ ಕ್ಯಾಬ್ನ ಎಡ ಮುಂಭಾಗದ ಡೋರ್ ಗ್ಲಾಸ್ ಪಡೆದಿರುತ್ತದೆ. ಕ್ಯಾಬ್ನ ನಿಂತಲ್ಲಿರುತ್ತದೆ. The complaints other authorities. He said, a unknown vehicle has dashed a rescue bench and he was wrong. He has parked his car on the other side of the road on the left side. But in that car, the left side door glass is broken and a big stone was there inside the car seat. These almost like a murder.
Who has stated this?
Father himself.
He himself says.
Yes, in the complaint, last time he was once again, ಸದರಿ ಅಪಘಾತ ಮಾಡಿ ಪರಾರಿಯಾದ ಅಪರಿಚಿತ ವಾಹನದ ಚಾಲಕತೆ ಮಾಡಿ ಸೂಕ್ತ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಲು ಕೋರಿದೆ. ಭೀಮಾ ಜ್ಯುವೆಲರ್ಸ್ ಮುಂಭಾಗದಲ್ಲಿ ನಿಲ್ಲಿಸಿದ್ದ ನನ್ನ ಮಗನ ಕ್ಯಾಬ್ ಎಡ ಮುಂಭಾಗದ ಡೋರ್ ಗ್ಲಾಸ್ ಒಡೆದಿರುತ್ತದೆ. ಕ್ಯಾಬ್ನಲ್ಲಿ ಕಲ್ಲು ಇರುತ್ತದೆ. During midnight, somebody must have murdered him because of this issue. In their own case, the complaint was given against an unknown vehicle. Admittedly, nobody has seen that. And nobody knows from which direction, which car came, what type of car it is, whether it is a car, lorry, mini vehicle, what motorcycle. Nothing is available on the car. Some vehicle, unknown vehicle, we can catch. This is happened at 2:00 midnight. Then we don't know how the police came to know that they called the parents. Father came and gave the complaint by morning. Admittedly, no vehicle number is, no type of vehicle, nothing is available on the card. They are not. But this is happened at 2 o'clock and complaint was given by around 9:30 in the police station. Then Lord, last night I see the Mahajan exhibit P4. As per the exhibit P4, it was drawn on the very same day, 16/10/2016. It starts from 10:30 to 11:30. The police went to the place of action and drawn on that. Let's read the matter. ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವರಾದ ಪ್ರಭಾಕರ್ ಜಿ ಅವರು ನಮ್ಮ ಠಾಣೆಯ ಸಿಬ್ಬಂದಿಯೊಂದಿಗೆ ಇದೇ ಠಾಣೆಯ ಮೊಕದ್ದಮೆ ಸಂಖ್ಯೆ 330/16 ಸಂಬಂಧಿಸಿದಂತೆ ಅಪಘಾತ ನಡೆದ ಸ್ಥಳದ ಪರಿಶೀಲನೆಗಾಗಿ ಬಂದಿತ್ತು. ಅಲ್ಲಿದ್ದ ನಮ್ಮಗಳನ್ನು ಸ್ಥಳದಲ್ಲಿ ಪಂಚನಾಮೆಗಾಗಿ ಪಂಚಾಯತ್ ರಾಜರು ಸಹಕರಿಸಬೇಕೆಂದು ಕೋರಿಕೆ ಮೇರೆಗೆ ನಾವುಗಳು ಒಪ್ಪಿ ಮೇಲ್ಕಂಡ ಸ್ಥಳಕ್ಕೆ ಬಂದ ಸದರಿ ಸ್ಥಳದಲ್ಲಿದ್ದ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವರು ಅಪಘಾತದ ಬಗ್ಗೆ ವಿವರಿಸಿದ್ದೇವೆ. They have explained how the action that has taken place. ದಿನಾಂಕ 16/10/2001 ಬೆಳಗಿನ ಜಾವ 2 ಗಂಟೆ ಸುಮಾರು 2 ಗಂಟೆಗೆ ಅಪರಾಧಿತ ನಂಬರ್ ಗೊತ್ತಿಲ್ಲದ ಅಪರಿಚಿತ ವಾಹನ ಚಾಲಕ ತನ್ನ ವಾಹನವನ್ನು ಅತಿವೇಗ ಹಾಗೂ ಅಜಾಗರೂಕತೆಯಿಂದ ಮಾನವ ಪ್ರಾಣಕ್ಕೆ ಹಾನಿಯಾಗುವ ರೀತಿಯಲ್ಲಿ ಚಲಿಸಿಕೊಂಡು ಹೋಗಿ ಅದರೇ ರಿಂಗ್ ರಸ್ತೆಯಲ್ಲಿ ಭೀಮಾ ಜ್ಯುವೆಲರ್ ಬಳಿ ತನ್ನ ಕ್ಯಾಬ್ ನಿಲ್ಲಿಸಿ ಫಾರೆಸ್ಟ್ ಆಫೀಸ್ ಎಂದು HDFC ಬ್ಯಾಂಕ್ ಎಂದು ಸದರಿ ರಿಂಗ್ ರಸ್ತೆಯನ್ನು ದಾಟಿ ಮುತ್ತಲಿದ್ದ ಇದಕ್ಕೆ ರಸ್ತೆ ದಾಟಲು ರಸ್ತೆ ಮಧ್ಯೆ ಅಳವಡಿಸಿದ ಸೆಂಟರ್ ಮೀಡಿಯಂ ಇಂದ ರಸ್ತೆಗೆ ದಾಟುತ್ತಿದ್ದು ಪಾದಚಾರಿ ಕ್ಯಾಬ್ ಚಾಲಕ ರಂಜಿತ್ 24 ವರ್ಷ ಅವರಿಗೆ ಡಿಕ್ಕಿ ಹೊಡಿಸಿದ ರಭಸಕ್ಕೆ ಪಾದಚಾರಿ ಸದರ ಪಾದಚಾರಿಗೆ ಸದರಿ ಕ್ಯಾಬ್ನ ಬಂಪರ್ ಕಾನೆಟ್ ಡಿಕ್ಕಿಯಾಗಿ ರಸ್ತೆ ಮೇಲೆ ಬಿದ್ದಾಗ ಸದರಿ ಕ್ಯಾಬ್ನ ಹಿಂಬದಿ ಚಕ್ರ ಆತನ ಮೇಲೆ ಹರಿದಿದ್ದರಿಂದ ತೀವ್ರತರವಾಗಿ ತಲೆಗೆ, ಕಾಲುಗಳಿಗೆ, ಹೊಟ್ಟೆಗೆ ರಕ್ತಗಾಯಗೊಂಡು ಸ್ಥಳದಲ್ಲಿಯೇ ಮೃತರಾಗಲು ಕಾರಣರಾಗಿರುತ್ತಾರೆ. ಏನು ರಾಷ್ಟ್ರ vehicle number is not known, type of vehicle is not known. Major was drawn between 10:30 to 11:30. Now they say cab has crashed. Who knows this? How do they come to know that this cab has involved in that? Who informed that this particular cab, whether it is a car, whatever it is, they say particularly a cab. How do they come? There is a complaint, 9:30, by 10 o'clock they say within half an hour, the complaint, nothing is on record to show that there is a cab. Within half an hour, they say cab is used. Without disclosing what type of cab it is. How they say particularly is a cab, what are the registration, what type of vehicle.
Whose statement is that it is a cab? Police or the?
Simply they are Mahajan in the say they say like that.
So that Mahajan is the police.
Oh, Mahajan, but who has stated this? If that is why they say it is a cab, which cab it is? What are the type of make and registration? And they should have specified particular that in the FIR written should have mentioned or in the Mahajan.
Unknown vehicle gang mention ಮಾಡ್ತೀರಾ? Unknown vehicle ಇದ್ರೆ
unknown vehicle
FIR ಅಲ್ಲಿ ಹೆಂಗ್
nobody has seen, nobody is scared that somebody has seen the vehicle.
It is also not his case that anybody has seen.
Yes.
It is some after the death somebody informed the police. Police will be
midnight, perhaps if it is on the daytime, perhaps some number of people will be going there. Correct. Somebody will identify it.
Correct.
In the midnight, 2 o'clock.
So now we'll have to rely on the police report. Police would have done some investigation.
Then what? They specifically mentioned in the cab. But that person who has mentioned about the cab, not has been examined before the tribunal. They should have examined the person who has actually seen the way accident.
Nobody has seen.
Nobody has seen. Then how do they? You are asking me like that. Nobody has seen the way. How the cab accident?
That is the statement of the police.
On what basis?
I can't answer your
No,
question.
no. You should know the basis. Otherwise, how can you falsely indicate the vehicle?
The first time the word cab comes in is by virtue of the Mazar investigation conducted by the police after the.
From the place of time of accident. It is not after the later.
No. Is it difficult to find out?
Yes.
Okay.
How do they come?
Immediately, if they are so very diligent and fast.
That particular should be there.
No,
When they are making some allegation against a particular vehicle, particularly their case itself in the complaint, nobody has seen the vehicle and nobody has identified the vehicle, nobody knows what type of vehicle is what. Within half an hour, if it is in the complaint that cab has
then it can be traced.
Yes.
Otherwise,
within half an hour, how can they develop it?
Correct.
Because the deceased is the cab driver, father of the deceased is also cab driver, and the vehicle involved now falsely implicated is also a cab.
Yes.
That's how the case has been manipulated.
Yes.
And so they have drawn the margin. Then last time we see the exhibit P5 is the
P5. These are records put in.
yes.
Whether there is any relation with this claimant and the involved vehicle?
We don't know. Even if it is there, when they are colluding with the claimant, do they disclose that they are the when they are supporting them?
No, whether you have come to know?
No, we can't make out. Even if you won't ask him, he will say, no, I don't know.
Of course, you can't. Even if you ask them, they will deny.
Yeah,
Only some third party you have to find them.
yes.
So, motor vehicles report.
Yes. But as per the motor vehicle report, this was drawn on 24/2016. It is almost like 8 days after that.
This is the offending vehicle.
No, this is the offending.
Front bumper.
Yes. Front bumper right side damaged. Bonnet damaged. Right side headlight damaged. Then front right side vertical damage. Vehicle damage. Person. That is more important. Should have also sustained very serious injury cannot be identified and come to the next point regarding PM report. So this is a false mentioning of the damages. Who has to make it a case that the driver came violent and acted to that. This is. Then last time can you see the sketch was prepared
Exhibit.
at the time of exhibit P6 now. At the time of majority. But here the place of accident show almost on the middle of the road, the car is coming in the straight direction, and the another direction is shown that the decision traveled from his car is shown on the other side of the road. Accident, and this is the place of accident. Who has seen the car has come in that particular direction?
Admittedly, no one.
Nobody knows. Then how they can draw the sketch. Whether the person who has shown this place has been examined before the tribunal. I have seen the accident. I was present at the place of accident and I was present when the sketch and measure was drawn. This is how the car came, this is how the receiver is traveling. And when this accident has taken place, who has informed to the police about the accident? Government. Then the law. Exhibit C7 is the peer report now. The injuries.
Exhibit?
Exhibit C7 is the peer report. So the injuries are the main injury is in the next page. Fracture of 7 to 8 ribs on the left hand. And regarding they said they sustained a head injury. Because of the head injury, he died due to the complaint given by the people who have seen the dead body also. On the top of it, you must look at the injuries to the head. Skull and vertebra intact. Then membranes intact, brain intact. And there is no head injury. In the complaint, they say he sustained head injury. Then so this totally falsifies how what type of injury is sustained. And all other parts of the body are intact. Except the fracture of ribs, 3rd to 8th rib. Then the PW1 has been examined. PW1 is
But do you admit that the deceased died due to road traffic accident? You don't admit?
our contention is it is not a road traffic accident at all, it's a case of murder.
But
the case of murder, even assuming, he might have met with an accident by any other vehicle, not me.
That's why I'm asking.
If that is, I don't know. How he died also, it is a.
Because the PM report says.
Totally fishy.
PM report says death was due to shock and hemorrhage as a result of multiple injuries sustained in RTA.
They might have said because they have followed the FIR. Maybe we don't know how he died. Whether other vehicle is involved in the accident or not is the question to be determined. If that is so, my lord, if really met with an accident, then his car was parked on the road and the left side of the door glass would be hammered. And then a huge big stone inside the car. That is their own case, is not our case. How it happened like that? And what is the explanation given by the police or the claimant?
Yes.
It is their own case, it is not our case.
Yes.
This creates suspicion. Lot of suspicion. That is a case of murder during midnight. We don't know what rivalry happened. Somebody, one people might have followed it during night and whatever they did, we don't know. That is totally under suspension. The police are not able to give any answer, or the claimant are not able to give any answer, or any of the witnesses are not able to give any answer. How the next day glass of his car is damaged and how there be a big stone inside the car. It is a case of murder. Murder case has been converted into, of course, not if he has crossing the road and vehicle dashed against it, and immediately the vehicle has been there, catch one of it, then whatever may be to his car, we are not bothered. Complaint was given against him, no weight. Nobody has identified the victim. Nobody has seen the accident, how it happened. And that, in spite of it, they have drawn the sketch and margin showing that this particular way the car came, this particular way he was parking, and this is the place of accident, so many. Therefore, the claimants are not able to find out or make out how this car was in the accident. But in this regard, PW1 method, Srimati Sujata has given evidence before. Admittedly, she is not a complainant, she is not an eyewitness, she do not know anything about the accident, she don't have any personal knowledge. Whatever the police records are there, on that basis, she has given evidence. How her evidence can be?
Who's that person?
Mother, Sujata, PW1.
Sujata.
So how is her evidence is relevant for proving the case? If she is an eyewitness, if she was traveling along with the deceased and she was sitting in her car and somebody came and dashed against it, then she might have seen, then it's a different case. Or if the car is, the accused car is waylaid and taken into the custody, then we can do. Absolutely nobody knows about the environment, how the accident has taken place, particulars of the case. She simply gives evidence based on the police. Therefore, not in the absence of any other cogent evidence, other evidence is complete. Even if I read the constitution portion of we are suggested that you are not in the accident, we could have been. Still, we are not for the satisfaction.
That she has accepted. That she must have accepted, she has not seen the accident. She not required to read.
No, even so many other points also we have elicited, but there is a lengthy cross-examination.
All right, you can read.
That's why I want to. Shall I read?
No, whatever is relevant for you, you can read.
In the classroom. By the insurance. ಪೊಲೀಸರಿಗೆ ದೂರನ್ನು ಯಾರು ಕೊಟ್ಟಿರ್ತಾರೆ ಅನ್ನೋದಕ್ಕೆ ಸಾಕ್ಷಿಗಳು ನಮ್ಮ ಯಜಮಾನರು ಕೊಟ್ಟಿರ್ತಾರೆ ಅಂತ ಹೇಳಿ ಪೊಲೀಸರು ನಮ್ಮ ಯಜಮಾನರಿಗೆ ಬೆಳಿಗ್ಗೆ 7:30 ಗಂಟೆಗೆ ಅಪಘಾತದ ಬಗ್ಗೆ ಫೋನ್ ಮಾಡಿ ತಿಳಿಸಿರ್ತಾರೆ. ಫೋನ್ ಮಾಡಿ ತಿಳಿಸಿದ ನಂತರ ನನ್ನ ಗಂಡ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಕೊಟ್ಟಿರ್ತಾರೆ ಎಂದು ತಿಳಿಸಿದೆ. ನಮ್ಮ ಯಜಮಾನರು ನಮ್ಮ ದೂರಿನಲ್ಲಿ ನನ್ನ ಮಗನ ಕಾರು ಸಂಖ್ಯೆ ಎಂದು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನಿಂತಿರುತ್ತದೆ ಎಂದು ಹೇಳಿದ್ದಾರೆ. By the time he went on 7:30, his car was also in front of the police station. Why they have taken these cars to the police station? It is not the accused car. This is one car was taken to the police station. ನನ್ನ ಮಗನಿಗೆ ದೂರಿನಲ್ಲಿ ಮತ್ತು ಪ್ರಥಮ ವರ್ತಮಾನದ ವರದಿಯಲ್ಲಿ ಯಾವುದೋ ಗೊತ್ತಿಲ್ಲದ ಒಂದು ವಾಹನ ಡಿಕ್ಕಿಪಡಿಸಿರುತ್ತದೆ ಎಂದು ನಮೂದಿರುತ್ತದೆ ಎಂದರೆ ಪ್ರಥಮ ವರ್ತಮಾನ ವರದಿ ಮತ್ತು ದೂರಿನಲ್ಲಿ ಕಾರು ಸಂಖ್ಯೆ KA-50-6335 ಡಿಕ್ಕಿ ಮಾಡುತ್ತದೆ ಅಂತ ನಮೂದು ಇರುವುದಿಲ್ಲ ಎನ್ನುವುದಕ್ಕೆ ಸಾಕ್ಷಿ ನನಗೆ ಕನ್ನಡ ಓದಲು ಬರುವುದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Instead of admitting it, she said she do not know reading and writing Kannada, but she has signed her signature in English. ನಮ್ಮ ಯಜಮಾನರು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋದಾಗ ಕಾರು ಸಂಖ್ಯೆ KA-50-6335 ಪೊಲೀಸ್ ಠಾಣೆ ಹತ್ತಿರ ಇಲ್ಲ ಎನ್ನುವುದಕ್ಕೆ ಸಾಕ್ಷಿ ನನಗೆ ಅಪಘಾತ ಮಾಡಿದೆ ಎನ್ನುವ ಕಾರನ್ನು ಪೊಲೀಸರು ಯಾವಾಗ ಜಪ್ತಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಪ್ರಕಾರ ಯಾವುದೋ ಒಂದು ವಾಹನ ಸಿಕ್ಕಿಬಿಡಿಸಿತ್ತು ಮತ್ತು ಶವವು ರಸ್ತೆಯ ಡಿವೈಡರ್ ಹತ್ರ ಬಿದ್ದಿತ್ತು ಅಂತ ಹೇಳಿರುತ್ತಾನೆ. ಸರಿ, ಒಂದು ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಆಲ್ಸೋ ಸಮ್ ಸೆಕ್ಯೂರಿಟಿ some unknown vehicle has been running. He has also not specified whether it is car, lorry, whatever vehicle it is, what type of vehicle. See, the security guard also not. ಪೊಲೀಸರಿಗೆ ಮತ್ತು ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ಗೆ ಕಾರು ಸಂಖ್ಯೆ KA3AB9546 ಇದು ನಿಮ್ಮ ಮನಸ್ಸಿಗೆ ಅಂತ ಹೇಗೆ ಗೊತ್ತಾಗುತ್ತೆ? ಸಾಕ್ಷಿ ನನ್ನ ಮಗನ ಹತ್ರ ಕಾರ್ ಕೀ ಇದ್ದಿದ್ದರಿಂದ ಗೊತ್ತಾಗುತ್ತೆ. That is not in the ದೂರಿನಲ್ಲಿ ನಗರ ಅಪಘಾತ ಮಾಡಿ ಪರಾರೆಯ ತಪ್ಪಂತ ವಾಹನ ಚಾಲಕನ ಹತ್ಯೆ ಮಾಡಿ ಸೂಕ್ತ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಲು ಕೋರಿದ್ದು ಭೀಮಾ ಜ್ಯುವೆಲರ್ಸ್ ಬಳಿ ವಿಭಾಗ ನಿಲ್ಲಿಸಿದ್ದ ನನ್ನ ಮಗನ ಕ್ಯಾಬ್ನ ಮುಂಭಾಗದ ಎಡಗ್ಲಾಸ್ ಹೊಡೆದಿರುತ್ತದೆ ಮತ್ತು ಕಾರಿನಲ್ಲಿ ಕಲ್ಲು ಇರುತ್ತದೆ ಅಂತ ಬರೆಸಿದ್ದಾರೆ ಎಂದರೆ in this car the left side glass is damaged and a big stone is there. ನೋಡಿ ಇನ್ನೊಂದು ಬರ್ತದೆ. ಭೀಮಾ ಜ್ಯುವೆಲರ್ಸ್ ಮುಂಭಾಗ ನಿಲ್ಲಿಸಿದ್ದ ನನ್ನ ಮಗನ ಕ್ಯಾಬ್ನ ಎಡ ಮುಂಭಾಗದ ಗ್ಲಾಸ್ ಹೊಡೆದಿರುತ್ತದೆ ಮತ್ತು ಕಾರಿನಲ್ಲಿ ಕಲ್ಲು ಇರುತ್ತದೆ ಅಂತ ಬರೆಸಿದ್ದಾರೆ ಅಂದ್ರೆ ಸರಿ. ದೂರಿನಲ್ಲಿ ಬಂದಿಗೆ ಠಾಣೆಗೆ ಹೋದಾಗ ಠಾಣೆಯ ಬಳಿ ನನ್ನ ಮಗನ ಕಾರು ನಿಂತಿತ್ತು ಅಂತ ಹೇಳಿದ್ದು ಕೊನೆಯಲ್ಲಿ ಭೀಮಾ ಜ್ಯುವೆಲರ್ಸ್ ಮುಂಭಾಗ ಕಾರು ನಿಂತಿದೆ ಅಂತ ಹೇಳಿರುತ್ತದೆ. ಇದೊಂದು ಒಂದಕ್ಕೊಂದು ವಿರುದ್ಧ ಇರುತ್ತದೆ ಅನ್ನೋದಕ್ಕೆ ಸಾಕ್ಷಿ ನಾನು ಹೇಳ್ತಾರೆ. ನನ್ನ ಮಗನನ್ನು ಯಾರೋ ದುಷ್ಕರ್ಮಿಗಳು ನನ್ನ ಮಗನನ್ನು ಯಾರೋ ದುಷ್ಕರ್ಮಿಗಳು ಕಲ್ಲಿನಿಂದ ಕಾರು ಹೊಡೆದು ನನ್ನ ಮಗನನ್ನು ಕೊಲೆ ಮಾಡಿರುತ್ತಾರೆ. ಕಾರು KA-6335 ಕಾರಿನಿಂದ ಅಪಘಾತವಾಗಿರುತ್ತದೆ. We have made a specific suggestion that in the case of murder somebody is killed.
ಸರಿಯಲ್ಲ.
ಸಾಕ್ಷ್ಯದಲ್ಲಿ ಮತ್ತು ಪಂಚನಾಮೆಯಲ್ಲೂ ಕಾರು ಸಂಖ್ಯೆ KA-6335 ಅನ್ನು ಕರೆದಿರುವುದಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಸಾಕ್ಷ್ಯ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದೆ. She do not know about the contents of the document. Still she wants to make allegation against the other vehicle, that vehicle caused the accident. She do not want to be in this case. She do not know what it is. ಸದರಿ ಅಪಘಾತವನ್ನು ಯಾರು ಕಣ್ಣಾರೆ ನೋಡಿರುವುದಿಲ್ಲ ಮತ್ತು KA-6335 ಅಪಘಾತಗೊಳಿಸಿಲ್ಲ ಎನ್ನುವುದಕ್ಕೆ ಸಾಕ್ಷಿ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳುತ್ತಾರೆ. If that is the way she says, she plead ignorance that she do not know whether this particular car is caused the accident and what is the accident. And who has to say before the court that this particular vehicle is?
FIR is filed. FIR is filed against your vehicle. Charge sheet also.
FIR against unknown vehicles.
No, later on in the unknown vehicle FIR ಆಗ್ಲಿಲ್ಲ. Unknown vehicle ಆದ್ಮೇಲೆ they have included your vehicle number and the charge sheet is filed.
That should be proper evidence before the criminal.
So what happened in the criminal case?
That I have to get the case. Usually in the pollution case, they find they pay the fine.
Whether he has pleaded guilty. That should be your first thing when you are saying.
No, usually there are 99.9% when they colluded with the claimants so that they don't come. Not even 0.1%. Except the KA-13
In
nobody will come.
In 304A, plead guilty is what?
Then I have to get the case.
304A plead guilty ಆದ್ರೆ
Usually,
IPC ಕೊಡಿಲ್ಲ. In other offenses, because of minor penalty and punishment, maybe 6 months, whatever it is, they can plead guilty. Here, 304A.
And get it.
May extend to 2 years.
But in 99.9% of other cases are acquitted and they have not seen the dirty cases, they will be acquitted in one year because of the failure on the part of the prosecution to prove that.
Yes.
And let the information also. To find out what happened.
Yes.
Then there are next important thing. ಕಾನೂನು ನಂಬರ್ ಕೇಸ್ ಅಪರಾಧಕ್ಕೆ ಸಾಕ್ಷಿ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಎರಡನೇ ದಿನದಾರರು ಮತ್ತು ಆತನ ಕಾರ್ಯ ಚಾಲಕನನ್ನು ಬೆದರಿಸಿ ಆಮಿಷ ಕೊಟ್ಟಿ ಕಾರು ನಂಬರ್ KA-50 ಸುಳ್ಳು ದೂರ ಕೊಟ್ಟಿದ್ದೇವೆ. ಕಾರು ನಂಬರ್ KA-50-63 ಯಾವಾಗ ಜಪ್ತಿ ಮಾಡಿದ್ರೆ ಅಂತ ದಾಖಲೆಗಳು ಹಾಜರುಪಡಿಸಿದ ಎನ್ನುವುದಕ್ಕೆ ಸಾಕ್ಷಿ ಹಾಜರುಪಡಿಸಿದೆ ಅಂತ ಹೇಳಿದರು. ಅಪಘಾತ ಮಾಡಿದೆ ಅಂತ ಹೇಳಲಾಗುವ ಕಾರು ಎಲ್ಲಿ ಸಿಕ್ಕಿರುತ್ತದೆ ಅನ್ನೋದಕ್ಕೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಪೊಲೀಸರಿಗೆ ನನ್ನ ಮಗ ಶವ ಬಿದ್ದಿದೆ ಅಂತ ಯಾರು ಯಾವ ಹೊತ್ತಿನಲ್ಲಿ ಹೇಳಿರ್ತಾರೆ ಅನ್ನೋದಕ್ಕೆ ಸಾಕ್ಷಿ ಗೊತ್ತಿಲ್ಲ. Here even the police also who they came to know that there was an accident and the body was named in the court and thoroughly Mr. Pitton and how they call the mother of the deceased to the police station the next day or not. Absolutely right. ನನ್ನ ಮಗ ರಸ್ತೆ ದಾಟುತ್ತಿದ್ದಾಗ ಪೊಲೀಸರಿಗೆ ಯಾರು ಹೇಳಿರ್ತಾರೆ ಅನ್ನೋದಕ್ಕೆ ಸಾಕ್ಷಿ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಹೇಳಿರ್ತಾನೆ. ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಈ ತರ ಹೇಳಿಕೆಯನ್ನು ಹಾಜರುಪಡಿಸಲು ಆಗುತ್ತದೆ ಅನ್ನೋದಕ್ಕೆ ನಾನು ವಿಚಾರಣೆ ಮಾಡಬೇಕೆಂದು ಹಾಜರುಪಡಿಸಿದ್ದೆ. There is no statement of the security guard, who is the security guard, where he was working, how he has seen the accident.
Whether security guard is a prosecution witness in the criminal case.
Here when we are specifically denied and we have taken the specific attention in the written statement itself that it is a case of murder. It is not as well surprisingly during the course of transformation we have taken the decision. We have taken the specific attention in the written statement itself that this car is not illegal.
Yes.
Therefore, it is incumbent upon the claimant to produce the security guard because he appears to be an eyewitness because there are no other eyewitnesses. They should have examined these witnesses. Seriously, specifically denied. ನನ್ನ ಮಗ ರಸ್ತೆ ದಾಟಿದ್ದ ಪೊಲೀಸರಿಗೆ ಯಾರು ಹೇಳಿದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ಸಾಕ್ಷಿ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಹೇಳ್ತಾರೆ. ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಈಗ ಹೇಳಿಕೆಯನ್ನು ಹಾಕುತ್ತೆ. ಸಾಕ್ಷಿ ನಾನು ವಿಚಾರಣೆ ಮಾಡಬೇಕು. ಕಾರು ನಂಬರ್ ಅಂತ ಅಪಘಾತದಲ್ಲಿ ಭಾಗಿಯಾಗಿದ್ದ ತಿಳಿಸಲಿಲ್ಲ. ನನ್ನ ಮಗ ಅಪಘಾತದಿಂದ ಆದ ಗಾಯಗಳನ್ನು ತೀರಿಸಲಿಲ್ಲ ಎಂದರೆ our specific contention is not tied to any accident by environmental vehicle. ದಿಶಾನಪಿ 7 PM ವರದಿ ಪ್ರಕಾರ ನನ್ನ ಮಗನಿಗೆ ತಲೆಗೆ ಮತ್ತೆ ಹೊಟ್ಟೆಗೆ ಮಾತ್ರ ಗಾಯಗಳಾಗಿವೆ. ದೇಹದ ಯಾವುದೇ ಭಾಗಗಳು ಗಾಯವಾದಂತಹ ಫೋಟೋ ಇರುತ್ತದೆ ಅನ್ನೋದಕ್ಕೆ ಸಾಕ್ಷಿ ನಿಮ್ಮ ಗಂಟ ಏನು ಕೆಲಸ ಮಾಡ್ತಿರೋದಕ್ಕೆ ಸಾಕ್ಷಿ ಬಂದು ಡ್ರೈವರ್ ಅಂತ ಕೆಲಸ ಮಾಡ್ತಾರೆ. ಈಗ ಏನು ಕೆಲಸ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ why is not working now? He just participated. He is a driver. Why they should get part? He is not working. He is a driver. He is also cab driver. ಅಪಘಾತ ಸ್ಥಳಕ್ಕೂ ಮತ್ತು ನಮ್ಮ ಮನೆ ವಿಶ್ವಾಸಕ್ಕೆ ಸಾಕ್ಷಿ ಅಪಘಾತ ನಡೆದ ಈ ಘಟನೆ ನಡೆದ ಸ್ಥಳಕ್ಕೂ ನಿಮ್ಮ ಮನೆ ಬಹಳ ಹತ್ತಿರವಿದೆ ಅನ್ನೋದಕ್ಕೆ ಸಾಕ್ಷಿ ನಾನು ಈ ಘಟನಾ ಸ್ಥಳವನ್ನು ನೋಡಿಬಿಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ. Even she has not seen the place of. ನನಗೆ ಇಬ್ಬರು ಗಂಡು ಮಕ್ಕಳು, ಒಬ್ಬ ಮಗ ITI ಓದುತ್ತಾನೆ, ನಿಶಾದ PH, ಒಬ್ಬ ಹುಸೇನ್ ಸಾಬ್ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಹೇಳಿಕೆ ಇದ್ದು ಅಪಘಾತವನ್ನು ಕಣ್ಣಾರೆ ನೋಡಿದ್ರಿಂದ ಶಬ್ದ ಬಂದ ನಂತರ ಹೋಗಿದ್ದಾನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. He has not seen the accident. It's a case of return, and he has not seen the vehicle also.
ಯಾರು?
The security guard. She has not admitted that he has not seen the accident. The security guard.
No, PW1 says
PW1 is
that mother.
his mother in the classroom.
That of course she has not seen, that's no dispute.
She has not seen. She is confirmed that even security guard also not seen.
How she can say that?
That's what she is telling. She is admitting. The class examination, she is admitting that even security guard also is not seen. ನಿಶಾನೆ PH ಅಲ್ಲಿ ಒಬ್ಬ ಹುಸೇನ್ ಸಾಬ್ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಹೇಳಿಕೆ ಇದ್ದು ಅಪಘಾತವನ್ನು ಕಣ್ಣಾರೆ ನೋಡಿದ್ದಲ್ಲ, ಶಬ್ದ ಬಂದ ನಂತರ ಹೋಗಿರುತ್ತಾನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ಸಾಕ್ಷಿ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ನಿಶಾನೆ PH ಅಲ್ಲಿ ನನ್ನ ಗಂಡನು ತನ್ನ ಹೇಳಿಕೆಯಲ್ಲಿ ಡ್ರೈವರ್ ಅಂತ ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾನೆ ಅಂತ ಹೇಳಿರ್ತಾನೆ. ಸಾಕ್ಷಿ ಮೊದಲು ಡ್ರೈವರ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದು ಈಗ ಮಾಡ್ತಾನೆ ಅಂತ ಹೇಳಿ. ನಿಶಾನೆ P 12 ವರ್ಷ. Rest of the thing regarding the application. If this evidence can this come to the conclusion that this particular vehicle is then they have, of course, they have done the mistake. PW2, he is one Prabhakar who is the mistake. In his examination,
PW2 is the IO.
Crime number protocol ಪ್ರಕರಣವನ್ನು ಸಲ್ಲಿಸುತ್ತೇನೆ. ಫಿರ್ಯಾದಿ ಸ್ವೀಕರಿಸಿ ಪ್ರಕರಣ ದಾಖಲಿಸಿಕೊಂಡು ಅಪಘಾತ ಎಸಗಿದ ವಾಹನ ಪತ್ತೆಗಾಗಿ ಠಾಣಾ ಸರಹದ್ದಿನಲ್ಲಿರುವ ಗ್ಯಾರೇಜ್ಗಳ ಬಗ್ಗೆ ಬಾತ್ಮಿಯನ್ನು ಪಡೆದು 14/2019 ಅಪಘಾತವೆಸಗಿರುವ ಒಂದು ಇಂಡಿಕಾ ಕಾರಿನ ಬಗ್ಗೆ ಮಾಹಿತಿ ಬಂದ ಮೇರೆಗೆ HPR ಬಡಾವಣೆಯ ಸರ್ದಾರ್ ಗ್ಯಾರೇಜ್ ಹೋಗಿ ಗ್ಯಾರೇಜ್ನ ಮುಂಭಾಗದಲ್ಲಿ ನಿಂತಿದ್ದ ಇಂಡಿಕಾ ಕಾರು ನಂಬರ್ KA-50-6335 ವಾಹನವನ್ನು ಪರಿಶೀಲಿಸಿ ಈ ಬಗ್ಗೆ ಗ್ಯಾರೇಜ್ನ ಮಾಲೀಕರನ್ನು ವಿಚಾರಿಸಿ ಮುಂಜಾನೆ ಸುಮಾರು 3 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಸುಮಾರಿಗೆ ಈ ವಾಹನವನ್ನು ನಮ್ಮ ಗ್ಯಾರೇಜ್ ಮುಂದೆ ಯಾರೋ ತಂದು ನಿಲ್ಲಿಸಿ ಹೊರಟೋಗಿರುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿದ್ದಾರೆ. ವಿಷಯ somebody a vehicle the person committed an accident it was underway and then he will directly go to the garage that would look midnight and he will come. How he come to know that he must have gone to the garage that to in particular area only. How it can be believed? Is it a possible thing? Is the prudent man will do it? Suppose if you want to escape from the place of accident, you will take away elsewhere. He will not go to the very same area and keep in front of the garage and run away from the place of accident even without informing the garage. Even assuming during midnight, how that owner came to know that somebody knew about left a car in front of my garage? How he came? Whether this person has been examined for the picture. All these are picked up story so as to fix this particular vehicle, only to help the client to get some compensation. Absolutely, these things cannot happen. That's what the investigating officer. ದಾಖಲಿಸಿಕೊಂಡ ಅಪಘಾತ ಎಸಗಿದ ವಾಹನ ಪತ್ತೆಗಾಗಿ ಠಾಣಾ ಸಮಿತಿಯಿಂದ ದೂರಿಸಿದ that particular police station, he inquired in the this garage. During midnight, any police officer is so prudent that go to all the garages to find out. And complaint itself is not filed. And he is not knowing that there was an accident when he came to know about the accident. Story connectivity is better. There is no connectivity at all. ಕಾಪಿಯನ್ನು ಪಡೆದು 16/ಮತ್ತು 2014 ಅಪಘಾತ ಎಸಗಿರುವ ಒಂದು ಕಾರಿನ ಇಂಡಿಕಾ ಕಾರಿನ ಬಗ್ಗೆ ಮಾಹಿತಿ ಬಂದಿದೆ. SBR ಬಡಾವಣೆ ಸರ್ದಾರ್ ಗ್ಯಾರೇಜ್ ಹೋಗಿ ಗ್ಯಾರೇಜ್ ಮುಂಭಾಗದಲ್ಲಿ ನಿಂತಿದ್ದ ಇಂಡಿಕಾ ಕಾರು ನಂಬರ್ KF-60-6335 ವಾಹನವನ್ನು ಪರಿಶೀಲಿಸಿ ಈ ಬಗ್ಗೆ ಗ್ಯಾರೇಜ್ ಮಾಲೀಕರು ವಿಚಾರಿಸಿ ಸುಮಾರು 3 ಗಂಟೆಯ ಸುಮಾರಿಗೆ ಈ ವಾಹನವನ್ನು ನಮ್ಮ ಗ್ಯಾರೇಜ್ನಿಂದ ಯಾರೋ ತಂದು ನಿಲ್ಲಿಸಿ ಹೊರಟೋಗಿರುತ್ತಾರೆ. That is all. How this particular vehicle is not an accident? That person came to the garage and says, I have committed an accident because of the accident. There is a damage. Okay, now I am leaving this vehicle. Tomorrow morning I will leave it. That is not their thing. And this particular investigator directly go to that particular garage only. Part time event. Apart from this garage, where all he has searched it. ನಂತರ ಅದೇ ದಿನ ಪಂಚರ ಸಮಕ್ಷಮ ವಾಹನವನ್ನು ಜಪ್ತಿ ಮಾಡಿಕೊಂಡು ಠಾಣೆಗೆ ಎತ್ತಿಸಿದ್ದು PF ಅನ್ನು ತಯಾರು ಮಾಡಿದ್ರು. Without authentication, how we can see that particular vehicle?
Mr. Vijay Kumar, you are not arguing.
In the garage, there will be number of
No, you are not, first of all, arguing criminal appeal.
Here also,
We are not deciding the case on the beyond reasonable doubt in a motor vehicles case.
whether these things are probable or not.
That is why once criminal probable or not is always.
If it is probable, then we are not accept. Everything is fishy, everything is imaginary.
Your
It's a story created by them, and there is no connectivity at all. There is no interlink at all.
no, how the investigating officer does that, you cannot argue that here in a motor vehicles case.
There is a serious issue with regard to the environment of the vehicle.
And you do not even know what has happened in the criminal case, what you are going to argue.
That I will get it, Maratha.
First, adna tagomba ಆಮೇಲೆ ಮಾಡಿ.
Please,
Otherwise, you are wasting the time.
please.
If he has admitted, accepted the guilt and the trial has gone through and he has been examined in the criminal case, which discusses the beyond reasonable doubt on the material propositions laid down by the prosecution, that is over. That can be relied by the civil court
I'll try to get the
in
entire
motor
record
vehicles
of
case.
I'll get the, try to get the entire record. Big time.
So see, now these cases, we can't dissect the entire criminal.
Here you are. Take a picture now.
No, I agree with you.
Here,
You-
but it's a case, they won't case that.
Illa, they have not said anywhere.
No. FIR complaint.
No, except for that statement which you read, leftally, that window is broken.
Even further, even with the law,
So you can say it is case of murder.
If they have a hand, there should be why a bulldozer is a bulldozer. Big
So-
store, yes. Why?
He may be carrying that stone to put it in his village in the ball.
Maybe. For that, he should be break the.
Somebody else must have broken the glass.
That should be there.
Have you done criminal trial? Have you done criminal trial? Madidira? Now, even if the person has seen somebody going inside the house with a stone,
But unless and until he close on him.
no, unless if he comes out, then one person is dead. Merely because somebody has seen A going with a stone inside the house, cannot be presumed that A is the.
Here in this case, nobody has identified the vehicle, nobody has seen the accident. And
No,
even
in a
if
hit and
it
run,
was-
nobody can identify. It can be because of the Bima Jewelers and other places. There must be some security guard who must have informed. It is not difficult.
He says, I have not seen the vehicle.
How can he see? How can the security guard?
Then where is the proof of this particular?
No, he can only say,
These things are probably in a motor
please,
vehicle.
you have to picturize yourself, putting yourself into the shoes of how you're seeing it.
Yes.
In a fast moving vehicle, you can only say that yes, some vehicle hit somebody. You can call the police. Police, it is the job of the police. What they will do? They will go to the nearest police station or see the nearest camera, whichever is possible.
That is also not.
Or go to the nearest garage workshop to see if anybody has parked the vehicle.
Yes.
That they will do their job.
That they should have done. That they have not done.
We
They have
don't
not
know.
identified.
That will not be available here. That may be available in the criminal case.
That is why they get the entire criminal.
Broken case, it's better. Technical examination.
See, I will tell you one thing, to my personal knowledge, it is very difficult to find out an unknown vehicle.
Yes.
You are right, in the middle of the night, it becomes more difficult.
More difficult.
More difficult, because you can't know the color, you can't know the board, you can't know whether it's yellow board or white board, and whether it is what type of vehicle. In the daytime, it is possible. If the persons who see wayside if they intimate the police, which intimates the next section, before he crosses the next toll gate or in between, it can be tracked. It's not difficult. You don't underestimate. No, you don't underestimate our police. They can do a great job if they want.
They can do.
If they want. But they create the loopholes.
They can make black into white.
Yeah, that I agree. Yes, call this matter next week at request. 2 weeks. Now you have to go and do a lot of investigation after 2 weeks.
It's a 50%.
No, I appreciate your work, but you can't now start dissecting the criminal case here.
That is not relevant also. Here they have the.
Just read through some of the judgment. What is the relevance? How much relevancy?
Various reasons he plead guilty. Because what is he? Plead guilty and he may pay a fine. Anyway, with that, civil liability may not be there. Insurance company, they will pay.
Even if he.
And even I don't say that they are benefiting their own people. By supporting them.
That is why your task becomes more difficult. If he admits and pleads guilty, then you have to cross-examine the witness to elicit that it was a collusion.
Yes.
So your job becomes more difficult here in the motor vehicles case.
Usually what I feel in most of the cases, they end their vehicle, end their claim because of various reasons. Obviously, is there.
Somshekar KM
Yavadamma?
59.
59. Yes, Somashekar AM. Matter is called out at 4:17 PM. There's no representation on behalf of appellant, so also respondent. Relist at 2 weeks. Both. Same 60 also.
61 Pawan Chandra Shetty.
VC Shivanna Gowda.
This is connected to yesterday's matter.
Same, huh? Same.
Common judgment.
That is a common judgment.
Then what will survive here?
No. Arising from the two petitions were there, perhaps one petition will ask for disposal of yesterday. Similar that only quantum has to be executed.
What?
It's a case of injury.
Uh,
When the date of accident 15/8/2018.
Same.
Yes. And
Yesterday's matter, there was more
Full compensation granted in addition to that, your RC plus granted in 20,000.
interlinear is there.
Connected, man.
No.
That's what. ನಾನು ಅವ್ರ ಘಟನೆ ಹೇಳಿದ್ರೆ ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇ ಹಾಕೋದು
ಆಗ್ಬೋದು ಏನೋ ಅಲ್ಲಿ.
To me, the compensation we now plan is on linear side. But considering yesterday's opinion that I have suggested that it may go
The case of
injury.
then ಇದರಲ್ಲೂ 40% ಕೊಟ್ಟಿದ್ದಾರೆ.
That's why.
What is your name? ಇದರಲ್ಲೂ 40% ಕೊಟ್ಟಿದ್ದಾರೆ. Future prospects.
Yes, but in fact, our company should have filed a appeal.
No. Now please come to page 22, para number 32. So obviously in the first serial number, you may not be having any quarrel. Accident is of the year 2018.
There is no scope for enhancement.
Towards medical expense, actual pain and suffering is correct. Indian bacon.
They have filed a appeal, therefore they want.
And loss of immunity, other incidents.
Future medical expense 60,000. Towards income later period 75,000. 30,000.
Yesterday's matter. What you are asking.
Running page number 39. Judgment page number 13.
But even here also 40% is pain and suffering 40. Medical expense actual. Conveyance right, how many days inpatient?
2 days inpatient.
2 days. That's also correct. Income during later period. What is the fracture and what are the injuries?
It's in running page number 30. Fracture of lateral condyling of tibia left knee and cartilage wound about 6.2 centimeters over the forehead and 2.1 centimeter over the fourth web space of right hand.
In this case, our disability invisibility was assessed 22%. If it is converted into finance, it is 7%. 8% is changed in this case. That is also on the X.
Loss of amenities 15,000 40. If there is a fracture,
Please put that.
that only will increase. 20,000 was what was ordered. Same thing in this case. Who was taken that yesterday? Yeah. Same repetition of all the facts also same. Only to the extent of loss of amenities of life, an additional 20,000 requires to be granted. There is no interference with regard to compensation awarded under other heads. It is partly allowed. Interest at 6%, balance to be paid within 4 weeks. Appeal is allowed. ಯಾಕೆ ನಿಮಗೆ ಕೇಸ್ ಇಲ್ಲ ಮೇಡಮ್ ಪವನ್ ಚಂದ್ರ ಶೆಟ್ಟಿಗೆ ಇದಕ್ಕೆಲ್ಲ ನೀವು ಅಪೀಲ್ ಆಗ್ತಿರಲ್ಲ? Client insist ಮಾಡಿದ್ರೆ ನಮ್ಮ ಕೋರ್ಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ತಾರೆ. Other also all others are waiting. You have to, as a lawyer, you have to advise your client which is a case to be appealed, which is a frivolous case, which is going to, of course, you can take your fee, but don't waste the time of court. It's a gross waste of time of court and then file going up and down. Because in fact, because of them not filing appeal, you are getting that. Otherwise, I would have reduced it. Sixty-five. 65. What was called out now? 61. Okay. To 63 adjournment.
64. More adjournment.
65.
65.
Nayak,
Krishna Venkatramana.
issue notice.
Final hearing, 66 adjourned, 67.
Who is this Mahadeva Swami PN? Mr. Shivanagoda. Who is this Mahadev Swami P?
Morning he was here.
Regularly appears in
Regularly.
for claimant. Claimant. He has not come today.
Yes, morning he was with me.
Ramakrishna idralla.
Dear Ramakrishna, he was searching for dear Ramakrishna, but at that time he was not available. Now I think he will be in local. Today there is a local.
Matters called out at 4:24 PM. There's no representation. I release this matter next week.
68 adjourned, 69.
Ravi Shankar Shastri G. Same also, no representation. Vishwendra.
No,
Our bed. Representation for the appellate. Release next week.
70, A.M. Venkatesh.
I'm appealing for the appellant, my lord.
Narsimha.
Lakshmi Narsappa, my lord.
Yes, Mr. Lakshmi Narsappa.
My lord, this is appealed by the insurance company and liability quantum as well as the interest, my lord.
Notice servaಗಿದೆ. Who appears? DS Sridhar.
ಅವರು ಹಾಕೊಂಡಿದ್ದಾರೆ.
We'll have it next week. He was present, I am told.
Sari Swami. ಆಯ್ತು my lord.
You are ready, Allah?
ನಾನು ready, Swami.
Counsel for the appellant is present. There's no representation for respondent. R1 is a claimant, is it?
ಹೌದು ಸ್ವಾಮಿ, ಕ್ಲೈಮೆಂಟ್ ಮೈನರ್ ಗರ್ಲು.
What about R2 and 3?
R2 is the owner of motorcycle 180. R3 is the motorcycle which I have insured, my lord. 3667. Both are owners of motorcycle R2 and 3, my lord.
Liability is on you.
Liability 50% is on me, my lord. That is question before this court.
All right, release next week.
Please.
72.
Shastri ji. Yeah, you are missing in the matter. Since your friend also was not here, I have adjourned it next week. Vishwendra eno irlilla. Next week. 71.
71 adjourned. Next week ಆಗಿದೆ ಸರ್.
71. Only 2.
72 ಸತೀಶ್ ಚಂದ್ರ ಟೈಮ್ ಬೇಕು ಅಂತ ಹೇಳಿದ್ರು ಸರ್. ಹೊರಟೋದ್ರು.
Limit
ರೀಚ್ ಆಗಲ್ಲ.
ತಿಳ್ಕೊಂಡು
ಇನ್ ಕೇಸ್ ರೀಚ್ ಆಗಲಿಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ 24th ಕೊಡಿ ಮೇಡಮ್. ಅದು ECA ಮ್ಯಾಟ್ರಿಕ್ಸ್.
Rangireddy. Rangireddy.
Number 72, Rangireddy baby.
No representation. Release next week.
Number 73.
Prabhakar Lakshmana Shetty. Why? ಯಾರು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬೇಕು ಇದಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ? ನಿಮ್ಗೆ ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ ಪ್ರಾಕ್ಟೀಸ್? 2 months. DM ಅಂದ್ರೆ ಏನು ಗೊತ್ತಿದೆಯಾ? DM ಹೇಳಿ. DM ಅಂದ್ರೆ ಏನು? ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಇದೆಯಲ್ಲ, ಅದರಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ. ಯಾವ ಕಾಲೇಜ್ ಓದಿದ್ದು? ಎಲ್ರಿ? ಚಿಕ್ಕಬಳ್ಳಾಪುರ. ರೂರಲ್ ಆದ್ರೆ ಏನು? ಲಾ ಇಸ್ ಸೇಮ್ ಫಾರ್ ಎವ್ರಿ ಒನ್. MV ಅಂದ್ರೆ MV ಫೈಲ್ ನೋಡಿ ಸ್ವಲ್ಪ. ರೂರಲ್ ಸಿಟಿ ಅದೇನು ತೊಂದರೆ ಮಾಡ್ಕೋಬೇಡಿ. ಲಾ ಇಸ್ ದ ಸೇಮ್. ಇಂಗ್ಲಿಷ್ ಬರಲ್ಲ ಅಂದ್ರೆ ಕನ್ನಡಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಯು ರೀಡ್ ದ ಪೇಪರ್ಸ್. Next week, you will argue, assist your senior. Next week, at request of counsel for appellate, you just next week.
24 and 75 adjourned. 76, Shivkumar P.
Shivkumar. Let's see, matters yaudi. Representation with the side. Perfect. Representation on the side. You next week after next 22 now. Week after next.
77, J. Anand.
United India Insurance Yaro.
AM Krishna Swami.
AM Venkatesh, the learned counsel AM Venkatesh is directed to take notice for R2 registry to show his name in the class list. Relist week after next.
78, Kumar P.
Same order, no representation. Relist week after next.
79 adjourned. 80,
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಿಮ್ಮ ಹೆಸರು SC Vijay Kumar. There are one D Vijay Kumar, one R also is there. You don't appear in MVC cases. Specific performance suit. So you are plaintiff or defendant? Defendant. The suit was initially decreed, then set aside. Your appeal came to be allowed. So you are the owner of the property. Possession not handed over. So what the first appeal court has done, asked you to refund the amount. You are not deposited. Court need not right now. Whether the whether the plaintiff has deposited the balance sale consideration amount. He made part payment only. After the decree. Not deposited. So your case is he did not have the amount.
Crucial property remaining 13 acres of land. And the fair consideration is only 7 lakhs. And the fair consideration is below the rate, below the state or lesser value. That reason they operate for moreover, he is an builder. He has created the document.
There is no representation on behalf of appellant in the matter is called at 4:32 PM. Counsel for respondent 1 to 4 is present. Relist next week. Relist after 2 weeks at request. Mr. Contract, Mr. Srinath, 64, registry to secure trial court records. What is your name? Sushmita. Why you are not arguing? Gopal Krishna has to come in all matters. How many years practice? Huh? 18. 4 years, 3 years cycle. You can start arguing MVC cases at least. It's the easiest case to argue. So tell your senior to give you opportunity, he can sit and you can argue.